Lordship.
What is the urgency?
Lordship, I have challenged the terms and conditions of the tender, and last date is Friday, Lordship, 9th, Lordship. So, Lordship, kindly take up tomorrow, Lordship. Otherwise, Lordship,
It will be taken up tomorrow, but I can't. It will be called or not.
Lordship, urgent motion, Lordship.
Correct, urgent motion. It will be listed tomorrow, but it is not sure whether it will be taken up for hearing or not.
My fate, Lordship.
Whoever wants, let it be taken as urgent motion, but leave up to the God.
Lordship, urgent motion, Lordship.
May I seek my Lord's leave?
List tomorrow as urgent motion.
My Lord, may I seek my Lord's leave to mention?
Yes.
My Lord, one matter, my Lord, which was heard on 31st of December, my Lord, last year, wherein an interim order was passed, my Lord, directing, my Lord, the sale authority not to publish the tender till 8th. That will expire tomorrow, my Lord. I have, my Lord, already filed an application for extension of interim order. But what happened, my Lord, in the meantime, they have again, my Lord, issued a corrigendum and said that the tender which was about to open on 1st of January, which was stayed till 8th of January, will be opened on 10th of January. In spite there being an interim order, my Lord, pending, subsisting.
Till 8 there is an interim order.
Till 8
So
there is an
they
interim
are
order.
going to open on 10th.
10th, my Lord, how could they, my Lord?
It is a wrong.
And my Lord, there is a wrong because, my Lord, they have been also directed to file a report in the meantime. And, my Lord, the matter
When
is
the
pending.
returnable date?
My Lord, returnable, my Lord, there is no returnable date given, but, my Lord, it is written, my Lord, that till January 8th, the authority shall not proceed to give effect to the said tender. My Lord, let this extension application be, my Lord, taken up tomorrow, your Lordship.
Extension application is
Yes, I have filed, my Lord, Can 1 of 2026.
under the application. Tomorrow we will listed as under application.
Thank you.
Under the heading application.
Very kind of you. Thank you.
Deeply obliged, your Lordship.
May I have-
Deeply obliged.
May I have my lords can leave to move on urgent matter, Lordship. I have been blacklisted without any show cause, without giving any opportunity of hearing. My bid security have been forfeited and I have been blacklisted for 3
When you have
years.
been backlisted?
Lordship, on 22nd of December, the order came into. Immediately I prepared the, Lordship, yesterday I affirmed it. Lordship, kindly
What is
permit.
the urgency?
Lordship, I have been blacklisted. I will not be able
Okay.
to participate in any tender for next
Is
3
there
years.
any tender is published?
Lordship, at any moment, Lordship, kindly take up the matter any day next week, Lordship. My bid security has been forfeited. I have been blacklisted without giving any show cause and opportunity of hearing. Straight away, they have been blacklisted.
Even if it is taken as an urgent hearing, what relief the court will get?
Lordship can remand it back, give me an opportunity of hearing. Let thereafter they take a decision.
The no opportunity was
No
given.
opportunity, no show cause, directly, without any intimation.
Yeah, not filed.
No, Lordship, I affirmed it. Lordship, kindly grant me leave to. I will serve copy next week, any day, subject to convenience of Lordship.
Next week. Will be listed under the heading urgent motion on 16th.
I'm
May I have your Lordship's kind leave to mention a matter for leave to obtain a tender number in a tender matter. Not by ineligible technical qualification, I write a letter. They postpone opening of the commercial bid. The commercial bid is open on 29th of December. I am 14% lower than the L1. The work order has not been issued. I'll just show 2 clauses below. I satisfy all the conditions just to form a cartel.
You are L1.
I'm sorry.
You are L1.
I should be L1 by difference of 14%. They technically find me ineligible and ask me for certain clarifications. I give all the clarification and I say, please consider it and postpone the commercial bid opening. They do that, postpone it. On 29th, we've opened the commercial bid. Now I see them actually, my bid I'm aware of. I know it's 14%, so it saves about 3 crores to the government exchequer. But they've not done it. But the work order has not been issued as yet. If it could appear tomorrow or day after, Milan. My instructions are to press for tomorrow because the work order gets issued, then everything becomes infructuous. I will actually take 10 minutes.
9th.
Item number 38, 39 and 40. Murder has granted deep. Entire vehicle has been seized and challan has been blocked, my lord. So, Lordship, kindly take up this matter, my lord. Otherwise, my lord.
38, 39.
38, 39 and 40, my lord.
38, 39, 40.
My lord has granted leave to move this matter, my lord.
Okay, it will come tomorrow. Leave.
Tomorrow has to be mentioned, my lord.
No, it will come as a top. If
Great.
it is not taken today.
Yes.
May I have my lord?
Serially, it is going on.
May I have my lord leave to mention, my lord, this is an application for traveling abroad. The petitioner has challenged the lookout circular before your lordship. Lordship has previously granted them to travel abroad, my lord. The petitioner is traveling abroad on 10th of
After lookout notice, this court granted leave.
My lord has granted leave, my lord. My lord has granted leave. My lord has also granted an interim order that whenever the petitioner are willing to go to the go abroad, they will seek permission from this honorable court, and will also give the itinerary to the enforcement directorate. My lord. On previous occasion, with same petitioner, my lord has granted leave, my lord. For medical reason, he's traveling to US, my lord, on 10th of January, my lord, which is on
So why
Saturday.
you are coming in the flag end?
My lord, I have
10th of
filed the
January.
matter. I have also mentioned on 2nd, my lord, January, my lord. It has not come. If it can be taken up tomorrow, my lord.
You file an application?
Yes, my lord.
Have you issued the notice to the other side?
Yes, my lord. I'm mentioning upon notice.
Why you are want to for medical treatment?
Medical reason, my lord.
Have you document?
Yes, my lord. I have annexed document. I will satisfy your lordship.
Tomorrow.
My lord, item number 51. Well, this matter was heard by your lordship on 2nd January.
Tomorrow is urgent motion.
On 2nd January. Item number 51.
Correct.
This matter was taken up by your lordship and heard this matter on 2nd January.
Correct.
Now, my lord, your lordship will remember this is the Kajunat. My vehicles was detained, my lord, by the marketing committee.
Correct.
Now, my lord, your lordship picks up this matter under the heading, same heading. My lord, that's why, my lord, this matter now came up in the additional urgent motion. Now, my lord, my vehicles was detained by the marketing committee. That's why, my lord, I cannot deliver this Kajunats. You also remember.
No, because I have put the additional, because this matter is already on the list, monthly list yesterday. That's why it has come, and what has not been listed, which has been mentioned yesterday or which has kept the notice, though I have kept as a additional list. So it will come tomorrow or day after tomorrow. Don't worry. No, now your matter will not go down. It will go up.
I will make it.
My lord,
I have taken care of yesterday's submissions of the lawyers. So I am taking care of
my
it.
vehicles was detained by
Correct. Please wait for 2 days. I think within 2
let
days.
me list under the heading urgent motion. At least
Urgent notice is already.
additional. Kindly see.
It will go serially, sir.
As for lordship,
The other person will be again problem. Then they will say my matter has gone down. That's why I kept which is been listed, which have mentioned the matter. I kept as the additional list. Please wait for the day. How far soon today? How many applications are disposed of? That will be taken.
my lord, may I have my lord's leave to mention item number 90 of my lordship's list? I'm mentioning upon notice. My lord will kindly remember this is that matter where the petitioner had wrongly remitted the amount in another account by just mistyping two numbers. And Yes Bank, it's recorded in my lord's last order, Yes Bank was ready to remit it back. GST was withholding the amount unnecessarily. Now they have filed the application, my lord. They have nothing on record against the petitioners. And they have not made any
GST wanted to file the
Yes,
paper.
my lord. They have filed an affidavit to which we have given a reply. There's nothing in their affidavit. Any day convenient to my lord may it appear. Any day subject to my lord. I'm not saying tomorrow, day after, any day subject to my lord. It's item number 90 I'm mentioning upon
Under
notice.
the heading and motion.
No, my lord, it's under adjourn motion, my lord.
Motion.
Any day subject to my lord. I shall give one more notice.
Okay, उसको रखो 19th
19th of January.
January urgent motion.
Great. my lord.
Item number
Great.
13 is fixed at 2 p.m. We have filed an application yesterday.
Come at 2 p.m. Come at 2.
The same is reflecting in the list. However, the physical application is before Honorable Justice Kapoor.
Okay,
If a requisition
come
may
at
be
2
sent,
PM, I will see if I necessary. I will release. Let me see. Let me see the file, sir.
it's pending before your lordship. It's for a final hearing today. We are the intervening party.
But you are not understanding English.
You come back at 2 o'clock.
Come at 2. If this court find there is a difficulty, the court will see. Let the record come before this court. What application you filed, what application before the other court. Let me see.
It is very embarrassing for me to mention this because I find everyone is mentioning for urgency. But my matter is fixed tomorrow at 2 p.m. I'm only praying my learned senior who's leading me in the matter that he is in some difficulty, is not in town. My lord, I'm only praying because it will be very embarrassing if I come tomorrow when the matter is fixed and I pray for time. I've served notice on the other side there, my lord.
You will not argue tomorrow.
Tomorrow, my lord. If I'm only praying, my lord, if any other day, my lord, since it was fixed at 2
Okay,
p.m.
you do one thing. You will be available.
I will not be available, my lord.
Let the junior come and mention. I will fix another day.
I'm very grateful, my lord. With my apologies, my lord. I'm very deeply honored.
Yes.
Lordship, may I be permitted to mention a matter for inclusion, irrespective of classification, Lordship?
Yes. What is the matter?
Urgency is that, Lordship, I being the petitioner is not
Seeing the list you are mentioning before this court, irrespective of the determination. Classification.
Yes, Lordship.
What is the matter?
Matter is that, Lordship, I am nurse.
You are
Actually.
nurse.
Yes.
Yes.
I got my registration
Ah.
in Odisha.
Indian Medical Council. Yeah, Nursing Council.
Indian Nursing Council at Odisha.
Ah.
And I came back my native place in
Ah.
West Bengal,
Ah.
and I applied for reciprocal registration before West Bengal Nursing Council, and I am not getting that.
When you applied for?
2024.
So, now 25, there is an urgency. It is pending here. Matter is pending here.
Matter is pending. Matter is already hard,
Ah.
and report other side
No, it is pending before this court.
before this court.
एक काम करो उसको ना 28 को जनवरी में अर्जेंट मोशन में रखो. Yes.
Well, may I be permitted to mention for inclusion, ma'am? Petitioner is a victim of cyber fraud. He obtained an order from landed ECM Barikpur for transferring the said amount in his bank account. But that order has not been complied with. The petitioner also filed a writ petition, and Honorable Justice Amrita Sinha has taken up the matter on 2 occasions, on 10th of September and 22nd of September, and directed the respondent bank to refund the whole amount. The bank said that they need some time to comply with the order of the Honorable Court, and the matter was returnable on 13 November 2025. The amount has not been returned.
22nd को रखो urgent motion. Urgent motion में 22nd.
May I have my lord's kind leave to mention a matter for inclusion? My lord, the urgency involved is the petitioner happens to be a rifle academy, a shooting academy.
Huh?
The petitioner happens to be a shooting academy.
Shooting academy.
Shooting academy. What has happened is, my lord, due to certain rifts with the West Bengal Rifle Association, the license of the petitioner has been suspended without granting any scope of hearing at all.
Whether any case initiated under the Arms Act against you?
No, my lord.
So why it has been suspended?
My lord, so what has happened is the office bearers of the West Bengal Rifle Association has some sort of a rift with the petitioner. No, without
Violation of the rules.
no, there is no violation of the rules according to the petitioner, my lord.
According to the petitioner, but the suspension order what reveals?
The suspension order says that what the one of the office bearers of the petitioner has done is he had made certain public posts. So owing to that, the Rifle Association is.
What is the urgency?
My lord, the urgency is the wards that are enrolled with the petitioner's shooting academy. They are not being permitted to play and take part.
How many years you are in academy?
Pardon me, my lord.
How many years you are in academy?
My lord, I have been I've been in academy for the last 3 years, my lord, and I have been suspended since the month of February. This
is a personal arm. This is a personal arm.
No, my lord, this is not a personal arm. This is a shooting academy. This is.
That's why the shooting academy. You have purchased your own arm, or you are using the arm of the academy?
No, my lord, these are personal arms. The arms.
I'm asking.
Yes, my lord.
So you got the license of your own?
Yes, my lord.
So who has suspended the arm license?
My lord, it's not the license of the arms that have been suspended. What has been suspended is the West Bengal Rifle Academy. So I am Rifle Academy. I am an institute that teaches words.
You are the institute,
Yes,
not the candidate.
No, my lord.
Institute license has been suspended.
Yes, my lord.
Tell like that. I don't know. It will take on February 1st week.
February 1st week. Deep.
Taken on 4th February.
Deeply.
As urgent motion. 4th February as urgent motion.
New motion, my lord. Inclusion in
New motion.
My lord would remember WPA 6963, your lordship had directed on the last occasion that it will be coming up in the first week of January.
Which one?
My lord, 6963, new motion, your lordship. I'm not able to say it in the monthly list of January, your lordship. May I just give the number, just only for inclusion?
Give the number.
I'm deeply obliged.
Inclusion, new motion.
The new motion, it is supposed to be listed today.
Inclusion.
Agency, the video issued a work order for construction of boundary wall in front of subdivision land reforms office, in front of subdivision, which is the connecting road for 70 families to the national highway with their following. If the construction starts, they will disconnect from the national highway. That's the urgency.
Disconnect
with the national highway. The boundary wall.
So what you prayed for here? Go to the civil suit. What the court will do here? Yes.
My lord, kindly allow this is for inclusion in the daily list. Ground of urgency, petitioner is an under trial prisoner and incarcerated for many years.
When he has been convicted, he is convicted. The petition is convicted. Under which section? Which year? What is the punishment?
I don't
Come ready with the. Come ready. All these questions, then I will see.
May I permitted to mention one restoration application, my lord.
Give the restoration application.
Your Lordship,
Day after tomorrow.
Your Lordship, item number 186, it's against CSC. There was a relocation of the meter box. Press inspection order will have
Is to be released.
Acha,
186.
186.
You are for the petitioner.
Petitioner.
Record an order 186. Counsel for the petition submitted. The matter is connected with the grant of shifting while electric meter.
Right.
Shifting while electric meter. Thus, this court is not having the determination. WTA number so release from the list of this case. We have with the parties to mention before the Supreme Court having determination. Yes, call the list.
My lord, my lord. Item number 154, my lord, it belongs to my lord electricity, my lord. Item 154 of the days list.
Same order. Connected with the electricity matter, not having determination. Yes. Call the list.
Yes, my lord, I beg to appear for the petitioner.
The petition is entitled to get an amount of rupees 7,82,282 and rupees 17,70,000 from the respondent number 7. The respondent number 7 is directed to refund the amount so and so within a period of 2 weeks from the date.
Grateful, ma'am. Much.
Next.
For the petition.
I beg to appear for the private respondent.
The respondent number 4 is directed to shift the electric meters of the respondent number 7 and 8 to the old from the old structure to the new structure within a period of 2 weeks from the date of compliance. But the petitioner shall not disturb the electric connection of the petitioner of the private respondents in any way.
Grateful, my lord, deeply obliged.
I am for the petitioner.
The notice issued by the respondent number 6 to the respondent number 8 dated 19 is directing to uphold the details of the employees of the cooperative bank, including the petition on a portal of each set aside cost.
Item 113 is a similar matter.
113 may be
Let
ordered.
it appear tomorrow as to be mentioned.
I am passing. Releasing it.
Similar matter.
Which one?
Same issue as item 3. Your Lordship,
So you are keeping watch on that. What is the judgment?
Watch out.
Item number?
113.
Not tomorrow. I will keep on the next 22nd. Kar do.
Your Lordship.
Before my lordship kindly recall.
Yes.
This is a matter I pray for my lord enlistment for hearing.
Office in the disposal room.
But I'm praying for enlistment for hearing. Lordship was kind enough to direct me to effect service upon the other side.
Yes.
And to come back today for fixation of it.
Affidavit is completed.
Yes, my lord. The reply.
On the other side.
My lord, Mr. Shobha Mojumdar is appearing on behalf of the Vishwabharat University. And my lord, this is my affidavit in reply. We have exchanged this.
Who is for the respondent? You are?
Yes, sir. Yes, Lordship.
Can it be fixed for hearing?
Lordship, may this matter be kindly fixed for hearing next week?
Not next week, next month. I will.
My lord, kindly termination, my lord, last 3 months. Termination of an assistant professor of a particular department. This is a second round of litigation. Previous round, their order was quashed by this honorable court, directed them to reconsider. Reconsideration, same order reproduced. Well, they are trying to drag this, my lord, the assistant professor. They are not allowing her to, my lord, join in the service. That being the situation. My lord, she is doing something, my lord, but not at par with that. This.
The matter is listed as to be mentioned on the prayer made by the counsel for the petition. It is submitted that the pleadings have been completed and there is an urgency in the matter and praying for fixing a specific date and time for hearing of the matter. In view of the submission made by the counsel for the petitioner, let the matter appear on कोई क्या date है? 17th February. 17th February.
My lord, I am praying for my lord.
January में कोई date
In the month of January, possible since a case of termination, my lord.
12 बजे कोई है? क्या time? 27 January at 12 noon. 27th January at 12 noon under the heading specially fixed matter.
Deeply obliged. Deeply obliged. The affidavit in reply may be, my lord, permitted.
Affidavit of reply filed by the petitioner be kept with the record. Next. Call. Yes, sir.
We have a petitioner.
Extension of entry model.
Yes,
এটা এফিডেভিট অফ সার্ভিস অফ রিট আর এটা নোটিশ অফ ইন্টিমেশনের এফিডেভিট
Your Lordship directed us to give an intimation. There are two affidavit of service. One
ফর দ্য রিট অ্যাপ্লিকেশন
for the writ petition and another for
Yes,
the communication of the order of.
Nobody is appearing.
No one is there.
লাস্ট অকেশন স্টেট ওয়াজ প্রেজেন্ট বর্ণালী গুপ্তা
Here I am told, Miller, that on the last occasion, the learned advocate appearing on behalf of the state respondent was.
নোটিশ ওয়াজ সার্ভড অন 17
Mr. Chakravarti, you are appearing in the matter.
বর্ণালী গুপ্তা
Bonali Gupta.
Item number 5.
5
Item number 5.
पीसी एंटरप्राइज
Hey, क्या मैटर दिया?
बस
PC
बाबा बोल
Enterprise.
Hey, बाबू. PC Enterprise.
না না ডিটেল ডিটেলিং 5 নম্বর আইটেম বর্ণালী গুপ্তা লাস্ট অকেশন
Okay, I am extending the time.
Yes,
Extending the interim order.
yes.
So they are not appearing. What can be done?
নোটিশ হ্যাজ বিন সার্ভড
Barnali Gupta is online.
In obedience to my lord's direction.
Somebody is there.
Served a notice.
on 17th itself they have received on 19th আর বর্ণালী গুপ্তা তো প্রেজেন্ট ছিল সেজন্য নোটিশ দেয়
The matter is listed as to be mentioned under the heading to be mentioned for extension of the interim order. Counsel for the petitioner has filed affidavit of service showing that the notice have been served
এটা কারেকশন
upon the respondent but none appears on behalf of the
এই জায়গাটা কারেকশন করতে হবে এই নাম্বারটা
for the
159 টা হইলে
trace for extension of interim.
আমি কারেক্টেড নাম্বার
Accordingly, interim order is extended till 17th of February 2026 or until further order whichever is earlier. Let the matter appear on 17th February 2026 at 2 p.m. 2 p.m. खाली है 17th February at 2 p.m. as a specially fixed matter. The petition is directed to inform the next date of hearing to the respondents. In the meantime, the respondent intend to file their affidavit in opposition. They shall file the affidavit in opposition within 2 weeks. Reply, if any, they are to be filed within a week thereafter.
You have only one evidence, Miller. Your Lordship, Miller, on the last order, your Lordship had indicated one number. It's stroke 19 stroke EA.
মানে এক্সিকিউশন নাম্বার
159.
159. This is 151, not
Instead of-
159. Miller, that's a different-
In the order dated 16/12/2025 at paragraph 3, the number shall be read as SC/19/EA/151/290
absolutely
instead of SC/19/EA/159 up to 2. Next.
My lord, in 6, I beg to appear on behalf of the.
My lord, I am for the petitioner, my lord. It has been, my lord, inadvertently filed, my lord, before the, my lord, group 9 bench, my lord.
Group
But
9 bench.
my prayer lies with the group 6, my lord.
So what is the prayer?
For challenging transfer, my lord.
Transfer in, my lord.
This court find record an order. This court find that counsel for the petition submitted. This court is not having the determination to hear the present application. Accordingly, WPA number so and so is released from the list of this court with the liberty to the parties to mention before the appropriate court. The petition is also given liberty to correct the group in the presentation form. In course of the day. Herein now you correct it. Next.
These have come at my.
Yes.
Lord, your lordship had been pleased to pass an order.
Yes.
In respect of an act of 2005.
Correct.
This Manrega. Kindly come to the order of your lordship. Order to thou. কোনটাই 23/12 রাষ্ট্রেই তো
Order dated 23/12.
23rd.
Yes.
Your lordship has been pleased to give direction to us to file a report.
Correct.
As regards the claim of the petitioners for non-payment.
Correct.
Of arrears. That is related to that. Now the subject matter of the writ petition. Kindly come. Volume 1. This is relating to the contractors, the petitioners, contractors supplying sand, stone chips and other materials for implementation of the project. And their grievance is that their payment is not being paid. And this is admittedly under the Manrega. But the grievance of the petitioner which is made under the prayer is against the state. Now kindly come to the prayer at page 19.
Prayer B.
Yes.
That's for
Therefore, my lord, I'm just drawing your lordship's attention to prayer B also, yes? To issue a writ of mandamus or any other appropriate writ order or direction directing the respondents, particularly the Department of Panchayat and Rural Development,
correct,
Government of West Bengal, to immediately release and disburse the pending dues bills for materials supplied like sand, bricks, and all that.
Yes.
And the third prayer is issue writ of mandamus commanding the respondent authorities to disburse interest as per government rate. Therefore, non-payment and interest followed by. Now, the question involved otherwise squarely in this writ petition is the payment of to those who have either worked or supplied materials under the Manrega scheme. Large number of writ petitions are moved before the division bench from 2022 onwards. Question arose whether the disbursement of fund by the central government to the state for implementation of this scheme has been properly utilized or not. There was a writ petition by the leader of the opposition with the allegation of misappropriation, fake job cards, fake bank accounts and all that. And there was a central committee report and they found their irregularities. And in that writ petition, the state government admitted there are several crores. And the state government admitted in respect of 4 districts, these are the misappropriated in the implementation with the supervision of the state. Now then, Mr. Bhattacharya's client filed a writ petition, Khed Majur.
Yes.
There, the claim initially was to payment to those Khed Majur about their areas for their work. that all these matters were heard together. Question arose that the implementation of the scheme which was stopped by the central government by exercising power under section 27 of the Manrega Act, whether it has to be renewed anew or not. But there was no direction in any stage of the proceeding, and the division bench constituted a committee with the nodal officer or representative, this comptroller general and attorney general's representative. They also found irregularities and misappropriation. And the division bench, by order dated, kindly come, this is very important. Division bench, by order dated 18 June 2025, in detail, directed the entire scheme cannot be put to cold storage. Since it has not been stopped, the scheme is not totally stopped by the central government, but it has to be continued and renewed from 1st August 2025. There was no direction to pay arrears. And this direction was simpliciter with the additional questions that the entire power authority shall now vest to the central government. State government is absolutely denuded to exercise any of the powers. They have, inter alia, will not have any say to the decision of the central government. And the money which has been collected in respect of the misappropriation of disbursement of fund shall now be transferred to the central government consolidated fund account. No, these are the directions I am giving to the Your Lordship. There is, unfortunately, is marked. Kindly don't mind.
No problem.
This is my way, yes. Now kindly come to the detailed marking stages.
Unmarked here. This is unmarked one.
That is better. That is better for me to read. For me to read my mark portions. This is kindly first come. It is actually relevant portions are from page 10. Page 10. It has been referred to the earlier decisions, orders, or affidavits, which
You are
were
referring
directed,
to which order dated? Order dated?
order dated 18 June 2025 of the division bench. In respect of Paschim Bongo Khed Mojur Samiti, this,
18 June
and
2025.
all these matters were heard together.
Yes. Page 10.
Yes, page 10, para 6.
Yes.
It is not in dispute that certain irregularities have been pointed out by the central team in the matter of disbursement of the measures under the central sponsor scheme. Action has been initiated, recoveries have been made, which is being remitted as the recovered amount is lying in the state nodal account of the Manrega's West Bengal. This is in respect of misappropriation in regard to implementation of the scheme with the allegation of fake job cards and all that.
Correct.
Para 7. In the affidavit filed by the authority as quoted above, it is stated that the said amount has to be remitted to the Consolidated Fund of India. Then onwards, entire power which was now being exercised by the state has been taken away by the division bench and is transferred to the central government. Page 7. In the affidavit filed by the authority as quoted above, it is stated that the said amount has to be remitted to the Consolidated Fund of India, and accordingly the state government should remit the recovered amount through a demand draft drawn in favor of Pay and Accounts Officer, Ministry of Rural Development. Then come para 8. At this juncture, the endeavor of the court is to the implementation of the scheme in the state of West Bengal, which has been kept in abeyance for the past close to 3 years, on the allegation that there is misappropriation, which is admitted, on the allegation that no action taken report and audit, all these were submitted to the state government, and that is why the scheme was stopped by the central government in exercise of the power under section 27.
Correct.
Then the division bench desired, para 9. None can take a stand that the person who had obtained the benefit illegally should be allowed scot-free, and that he should be enjoyed the benefits which he had obtained by adopting illegal means. Such of these persons have to be dealt with by firmly, and whatever disbursement have been made in such persons or any 50 such persons favor have to be recovered, and there can be no second opinion on the said decision. Then 10. At this juncture, the court is concerned about the implementation of the scheme in the state of West Bengal prospectively. Kindly mark it.
Yes.
Prospectively. The scheme of the Act does not envisage a situation where the scheme will be put to cold storage for eternity. There are sufficient powers vested with the central government to inquire into the irregularities or illegalities in the manner of disbursement of the pay wages, or in the manner of approval have to be granted, etc. However, there can be a line drawn between past actions and future steps to be taken to implement the scheme. Kindly come to the next page, page 12. The para 13 onwards.
Yes.
Therefore, while allowing the central government to proceed with the inquiries, kindly mark it again, as recommended by the central team, not only in the 4 districts, but also in the other districts as mentioned in paragraph 7 of the affidavit as quoted above, this court directs that the scheme be implemented prospectively again, the division bench said, with effect from 1st August 2025. While doing so, the appropriate authority of the central government is fully empowered to impose special conditions, restrictions, and irregularities. These are for prospective implementation. Now, kindly come to para 14. The London Advocate General submitted that the payments are to be made to the national portal, and there can be no intermediary in the matter. Then, kindly come to 16. This may be important. Therefore, by implementing the scheme in the state of West Bengal, prospectively from August 2025 onwards, the central government and the authorities of the central government who are in charge of the implementation of the scheme are entitled to impose special conditions so that to ensure that whatever had occurred 3 years prior to should not recon. Necessary steps be taken in this regard and special directions be issued and communicated to the state government, and thereafter the directives which also shall contain the specific directions to the district magistrates. 17, 18, 19, these are extremely important. Apart from that, the issues which have been pointed out in paragraph 7, subparagraph 2, namely that blanket permission for land development work, this is also very important, kindly mark it, should be stopped, and DPC should be accorded sanction on the case-to-case basis. Para 18. Apart from that, the central government would be entitled to impose any other special conditions that would warrant and ensure that the scheme is effectively and properly implemented in the state without giving any room for any irregularity or illegality being committed. Para 19. The state shall comply with the directions in strict compliance, and such directions which may be issued by the central government are non-negotiable. And they have to be accepted ipso facto, and the state government be implemented only if this is done. The citizens of the state of West Bengal will be benefited, and works can be performed, and they can be paid. Then, my lord, kindly come to the last. This is the direction of the division. This was challenged by us to the Supreme Court. Supreme Court dismissed this on the observation which is not recorded, that the entire power is given to the central government. There is no bar to implement.
You are challenged.
Yes. Yes. We have challenged. Supreme Court said that the entire power has been given to you. It has been done to observation, not recorded, that it has to be implemented prospectively from 1st August 2025.
Correct.
Now, my lord, an application was filed by the state for payment of arrears. Although state, the allegation in all these writ petitions were against the state, they filed an application for payment of arrears.
Yes.
That has been moved, and we took a preliminary objection to the maintainability. Whether arrears before 1st August 2025 be paid. The division is directed. Maintainability question is left open, and we have filed the affidavit. That is not maintainable. No direction is given by the division bench for arrears before 1st August 2025, and therefore there is no question of releasing arrears subject to the hearing of the application finally. Now, even if, unfortunately, this division bench order was there, one after another matter is being moved by forum shopping in different courts. Malar Mrs. Hiranmoy Bhattacharya referred one matter to division bench. Attempt was made there in the land bench. Then another matter was moved Then another matter was moved before the division bench of Honorable Justice Soman said. Their loss is also transferred into division bench. And this is the last matter. And this is before your lordship in respect of the first question is not at all a residuary matter, is relating to your lordship has seen land development and rural development, it is land matter. Thirdly, when the division is in session of the matter of the entire thing, whether this writ petition is maintainable with the single bench.
Which matter is pending where? Where is the order? The division, still the matter is pending with the division bench?
This matter is pending. The order which your lordship has
This is
drafted.
still pending?
Yes.
Okay.
Still pending.
Okay.
And I have submitted an application has been filed by the state for releasing the areas.
In this application?
Yes.
In this writ petition?
In this writ petition.
Can application was filed?
Application filed by the state. We have taken the question of maintainability because state main allegation.
What has happened to that application?
That will be heard in the next day.
Okay.
That is pending. We have filed the affidavit on the question of maintainability and other things. No area was granted ever.
Yes.
So therefore, whether this writ petition, which virtually is a claim of arrears for the work and the order supplied, can be heard by the single bench.
Okay.
Number one. Number two, your lordship is aware that when an issue is raised if in a judicial forum and this is being adjudicated by the higher forum, the single bench has no determination. And the doctrine of merger will come only when, yes, before the division bench. Therefore, this is absolutely a malafide petition, completely misleading the court, and unfortunately, by a counsel who appeared before the division bench in these matters. He should have apprised your lordship that these are the matters pending with the division bench. And what is the order? Even if prayer is made against the state, your lordship was asked to give a direction upon us to file a report.
No. That's why on that day I told you, on that day your state authorities also stated that the center has not released the fund. That's why this court has passed an order.
No, state, there is no direction in your lordship's order with great respect. Kindly come to once in the list, 23rd of December order.
Yes.
No, 23rd December order.
Yes, it is there.
Just a minute. কোথায় গেল অর্ডারটা কোথায় গেল দেখো না ফাইলিং ভেজে খেয়ে দিই Yes, well, I have got it. 23rd December order for your lordship.
Yes.
The matter was listed on 12th December 2025. The learned advocate for the Union of India prays for time to take instruction. Today, the learned counsel appearing on behalf of the Union of India has brought some documents and submits that the state has not complied with the direction and has not submitted proper documents to the central government for release of funds. State now, this is relating to the action taken report, audit, and all that misappropriation, all this. From that ground, we stopped this releasing of fund. Section 27 was invoked, and therefore the fund was not released. And that was taken cognizance of by the division bench.
That's why.
I'm coming to that. Then come to the next paragraph. Considering the above, this court finds that the central government is required to file a report. Now, straightway, your lordship had been pleased to say central government is required to file a report.
Correct.
The matter is being adjudicated by the division bench.
Correct. That's why, Mr. Chakravarti, that's why this court, when the matter was moved,
Your lordship ought to have been apprised.
Just a minute. Your advocate and the state advocates appeared. This court has specifically put the question to the state authority, why you're not releasing the fund. The state authority stated that the central government has not released the fund. This court has asked the central government has taken that time. Then I have fixed the matter on 23rd, they have brought some loose paper. Then this court has, then he stated that he will file the report. Then court has passed an order for it.
I admit that is a mistake on our behalf.
Blaming the court that the court has passed an order.
No, I'm not blaming.
If your advocates are not coming with the proper brief, what the court will do. This could have been mentioned because the notice has been served. Once your advocates are appearing before the court, they could come. Other, they have no instruction because the court has given the time. They have come with the instruction. They have not given all this brief, which now you are submitting before this court.
Milord,
That is the
I am
problem.
not blaming the court at all. I am
You are
saying
reading the order of the court and
that
telling the court has passed an order directly. The court so moto has not passed an order. Court has given the opportunity to the union as well as the state.
But
and
on the
union
date,
has
kindly
come.
remember on the date when I mentioned, I admitted that is a mistake on our
Correct.
part, that they ought to have drawn the attention of your lordship. What is the division bench order? That apart, I also mentioned
Correct.
that the learned counsel who moved this writ petition, who is appearing before the division bench, he also ought to have
That's why you kept the matter. That's why I'm hearing you. I kept the matters to be mentioned so that I can
Exactly.
Bhattacharya.
Now comes the moot question.
Yes.
Whether lower lordship will hear the matter or refer it to division bench.
Let me hear Mr.
And
Bhattacharya.
I have last submission. That apart, in respect of the judgment and ratio decided by the 1998 Supreme Court, Volume 1, SCC, page 1, if court has no determination and
That's
thereafter
correct.
subsequent division bench,
That's why.
that order is a nullity.
That's correct.
This is a matter which clearly falls to the land jurisdiction, Group 1.
Correct.
No residuary.
No problem.
And secondly, my lord will kindly, for ends of justice, it is my prayer that all questions which are raised in the writ petition are ipso facto claim of arrears for their bill submitted in respect of supply of certain materials by the contractors. The third question which is to be adjudicated by the division bench also, this on the affirmation of the writ petition, that there was an agreement between the state and the contractors, whether we are bound by the agreement or not. Number one, in respect of the latest judgment. Therefore, this matter has to be heard by the division bench. These are my submissions.
Okay. Yes, Mr.
But I am sorry to say, I am constrained to say that the learned solicitor has not been instructed or he did not apply his mind at all. Maybe under huge pressure. The writ petition, which was moved as a public interest litigation by the rural Khet Mojurs, that under the Act, it is the bounden duty of the state and the center to provide us with job. And you are not providing us with job. But I had the privilege, I feel proud that I had moved that petition. And there the Honorable Court found that the state and the center is fighting, breaking their heads for whatever reasons. But the Khet Mojur should not be deprived. After 3 years of hearing all this, I would say with deepest of respect, frivolous points were argued. And ultimately, court came to finding that you cannot keep it suspended. You have to start it. Now, it is obviously prospective because those periods have gone. There's nothing saying that this is prospective, they have retrospective operation. These are all with deepest of respect, Lord, argument having no sense and value. But
I object to this repeated personal attack. I object. I also hold a position.
Okay.
Yes.
Please.
He should confine his argument to the points of law.
Whatever I argued, have argued in the precincts of
No,
law.
I
have not
object it.
You might object. You have right to object.
Yes.
Now, that division bench order, the central government took to the Supreme Court. The Supreme Court dismissed outright, saying that it is the statutory obligation. Now, these petitioners are not the Khet Mojurs. They are the contractors who have delivered their obligation. They have paid out of their own pocket. Now, I have demanded the money from the state. And my lord has correctly been pleased to remember that the state council said that we cannot pay since the center is not paying. And thereafter, my lord directed the central government to file a report. And this is completely and exclusively within the jurisdiction of the residuary court. No question of forum shopping. This is not land dispute. My payment of money for the work I have done is not a land dispute. Now, whatever might be, my lord, the fighting between the state and the center, my lord, claim. If it is found to be not fraud, I am entitled to get it. And that's why my lord said that I will direct the payment to be released.
No, but Mr. Chakravarti has argued one point. The state has made an application in the division bench for release of the fund.
I am not aware. I am not party there.
If it is release of the fund.
No, I am not party there.
If it is that matter, release of the fund is pending before the honorable division bench. What this court will do?
No, my lord. Again, my lord, that application, I don't know what is the application before the state. I have not yet been served, though I am, my lord, as arguing counsel, it might be served upon the advocate on records. That relates to only, my lord, the question of, my lord, the execution of the job for the benefit of the rural employment. But mine is completely different. My duty, I want the state must disburse it. Now they have taken up the responsibility on the center. Therefore, I have nothing to do with the center here. That's my prayer. Therefore, Lord, my prayer that a work order was issued. I have worked. I have delivered the materials. My payment should be released. There is nothing to do with not. Let us see the state petition filed by the state before the other division bench. Then the additional will definitely produce it.
Yes.
No, if it is a submission that he has no grievance against the state government, entire payment has to be made by the state. Can you record that?
That is my prayer.
No. Instead of asking us to file a report, let the state file a report.
The state has filed the application for the payment of the arrears. That matter I am not separating. So I am not in position to say something. I have to take instruction.
That release of the payment in respect of the whole or respect of one work?
Yes.
But
no, only in respect of the wages of the rural employment.
That's why. What is the point? What is the application filed before the division bench for release of the fund?
I have to take instruction on this.
কিন্তু অ্যাপ্লিকেশনে কপিটা আছে কপিটা আছে
এগুলো সব পাচ্ছি না
নেই
না ফাইল আমি অর্ডারটা দেখিয়ে দিচ্ছি
বলতে আমাকে
application that is for the state to serve you, not for us.
কোথায়
The application is copy.
এটা তো আগের অর্ডার
No.
Last date also I placed one letter before your lordship that on December 6th of last year that the commissioner undertaken to the government of India and issued a letter to the state government regarding the implementation of the Mahatma Gandhi National Rural Employment Scheme. The state of West Bengal compliance of the order of date of this honorable court dated 18/2025 with minor.
Yes, it was processed. Correct.
And in that letter,
Yes, may I just interrupt? This is the order as regards the application file and the regarding the areas.
আমার কাছে একটা কপি নেই দিয়ে দেবো আরে পরে দেবে কি এখন আর্গুমেন্ট হচ্ছে
তো পরে নিয়ে জজ সাহেবের কাছে নিয়ে দেখো We have taken preliminary objection to the maintainability of the application. This is directed to a file affidavit. We have filed the affidavit. Now this application is to be heard on the returnable date.
So you do one thing. I am keeping up next week. You bring this application. But
Let
is
us
the
speak.
prayer?
No, order is clear.
I would expect not
Firstly, the petitioners are taking areas
a copy.
Mangara or illegally withheld from 2022. With regard to which work it is in total?
This application is, I submit with responsibility that all payments to be released prior to the order passed by the division bench, all areas.
Correct.
Areas to what respect?
To
Let us see the
respect of
application.
payment.
Let us see the application.
Let the application bring on
Let it be
record.
Then kindly also record the statement of Mr. Bhattacharya.
That's my
That his
prayer.
grievances against the state only.
Correct. I will record this.
That
I will
is my
record this. I
prayer.
will record your submission and let this application.
But
state government is there. Fund will be released from this central government. But that is the under the scheme, your lordship.
But then the order which has been passed by law has to be modified.
That's why, because on seeing the prayer of the petitioner, this court has made a query to the state.
Yes.
State has put their hand on the government. This court has put a question to the central government. That's why they are not able to give the total details that the court has passed an order for report. Now the new things has come which has not been brought before this court. Now
Yes.
Mr. Chakravarti has brought several things. Now there is one question. The state has filed an application before the division bench in the pending matter for release of the fund. Whether that release of the fund
Of
will be
areas,
published,
areas.
areas with regard to that is the whole.
That if that covers everything, then of
That's
course
right.
the petition has to be adjourned. No doubt
Correct.
about it.
That's what I'm telling.
That's-
That if it is
why should I
if the total amount is involved in that application, then nothing can be done. This application either
Then we shall join there.
or to cyanide. These are the two way.
No, the other questions.
Let us
with
see the
regard to-
application.
with regard
Other
to the-
question, Milord, subject to correction. Subject to correction. Whether even if your lordship finds that these petitioners are entitled to these benefits, who shall release the fund? State, that is the claim, that is the
Yes,
candidate
yes.
prayer.
Correct.
So therefore, when in the midst of a division bench, in implementation of a scheme which squarely falls on the claim in the writ petition of 2025 Act, and the central government is in session of the matter, only obligation under the division bench judgment to implement prospectively, and the division bench has
Implement prospectively scheme not with regard to the pending amount. Implement the scheme with regard to the
No, I
work.
am submitting, the division bench has not said about payment of arrears.
That's why the division bench has not stated that the arrears is to be released only the prospectively
Yeah.
which the work has been allotted.
Prospectively, a scheme has to be implemented.
We have
That's
to
why
take
Mr.
the
Chakravarti,
common sense
court-
into
Court
consideration.
has to see whether the claim of the petition is also covered under the judgments of the division bench. They are also coming under the fraud bills or not. That is to be seen. Second thing, the state which they have made an
Well,
application.
let us see the application without wasting court further time. Let us see the application and additional.
No, kindly also record.
I will
Submission
record,
of Mr.
I will
Bhattacharya.
record, I will
That
record
his
both.
grievance is
That's
against
my
state.
prayer.
By an order
Or the
dated.
order is otherwise.
By an order dated.
Then may I take leave?
Yes. By an order dated 23rd of December 2025, this court directed the central government to file a report by way of an affidavit by 5th of January 2026 after serving the copy to the learned counsel for the petitioner as well as the learned counsel for the state of the West Bengal. And the counsel for the petitioner as well as the state Bengal is liberty to file any reply, if any, by 13th of June 22. After the said order, learned ASGI has mentioned the matter and submit that the total facts was not brought before this court before passing the order dated 23rd of December 2025, and accordingly, as per the prayer made by the learned ASGI, this matter is fixed as to be mentioned after issue notice to the all parties. Today, when the matter is taken up for hearing, learned ASGI submits has brought to the notice of this court to the order passed by the Honorable Division Bench in WPA within bracket P 237 of 2023 within bracket Paschim Banga Khet Mazdoor Samiti and another versus Union of India and others and other 3 writ petitions dated 18th June 2025, wherein the Honorable Division Bench has passed certain directions and also
Implementation of
directed the central government to implement the scheme prospectively with effect from 1st August 2025.
Now kindly record, my lord, that no direction was given in the said order to release the area.
That's I am coming. Don't worry, Mr. Chakravarti, I will record all these things. Learned ASGI further submit that in the order on the Honorable Division Bench has not passed any order for release of any payment under the said scheme. Full stop. Learned ASGI further submit that independence in the said writ application, the state has filed an application before the Honorable Division Bench praying for a direction upon the central government for release of fund. The central government has raised objection and affidavit in opposition is filed in the said application and the same is pending for adjudication. And thus he submit that the application which has been filed by the petitioner is not maintainable before this court, and this matter is to be referred to the Honorable Division Bench. He further submit that on the second count also the writ petition is not maintainable, as this court is not having the determination to hear the application filed by the petitioner, as the petitioner has claimed the amount with regard to the development of the land. And the land development, this court is not having the determination to decide the matter with regard to the development of the land. Full stop. Any further?
Only anything more. The submission of interest certificate.
You give. No, your submission is
Yes, yes.
okay. Full stop. And it, Vikas Ranjan Bhattacharya, senior advocate appearing for the petitioner, submits that the writ petition pending before the Honorable Division Bench, the petitioners are not the party. Full stop. The petitioners have filed the present application not with regard to the development of the land. They have filed an application for release of the amount, and they have filed an application they filed the application for direction upon the state authority for release the amount which the petitioners have executed. He further submit that he is not asking any amount from the central government. His claim is against the state government. He further submit that in the writ application, the petitioners have prayed for the amount and not for the land, not prayed for any order for development of the land. And thus such, this court is having the determination to decide the matter. Full stop. At the full stop. The Indian Council for the state submit that though he is appearing for the state, but he is not appearing before the Honorable Division Bench in the about that matter. And as such, he is not having the knowledge what is the application filed before the Honorable Division Bench with regard to the what amount the state want to release. He is not having the knowledge what quantum of the amount the state has filed an application for release by the central government. The learned counsel for the state further submit that though the petitioner has prayed for a direction upon the state authority for release of the amount, but the state authority cannot release the amount unless and until the amount is released by the central government. Heard the learned counsel for the respective parties. This could find that though the petitioner has claimed the amount with regard to the work executed for the development of the land, but here the petitioners are not prayed for any order for development of the land, only they have prayed for release of the amount which the petitioners have executed. This court is having the determination of all matters within bracket motion and hearing under Article 226 of the Constitution of India under residuary Group 9, including hearing of the writ petition irrespective of the classification, including the application connected thereto. This court finds that the petitioner has filed the writ application only for a direction for release of the amount. Thus, the writ petition filed by the petitioner is squarely covered under Group 9. As regard the other maintained point raised by the learned ASGI that the matter is pending before the Honorable Division Bench.
May I just that I have submitted, possibly I forgot to remind your lordship, that the claim raised in the petition is in respect of an agreement between the state and the contractors. We are not aware of that.
ASGI regarding the application pending before the Honorable Division Bench. With regard to the prayer made by the state authority for release of the fund, neither the petitioner nor the state authority have come with the clarity what application has been filed by the state for release of the fund. And as such, this court is of the view that point is to be taken into consideration only after placing the application filed by the state before the Honorable Division Bench for release of the fund by the central government. The Union of India is directed to file the copy of the application filed by this, or you will file the copy?
Copy of
Yes,
the
copy.
application.
Copy of the application along with the document which has been filed by the state authority before the Honorable Division Bench for a direction for, upon the central government for release of the amount on the next date fix. On the next date fix. Let the matter.
No, only.
I will record.
copy.
Let the matter appear within 1 week or 2 weeks.
2 weeks.
Let the matter appear on. आज कितना तारीख है? 8 7 तारीख है. Let the matter appear on 27th of January 2026 under the same heading.
Not your loss. For filing a report within certain time.
Full
That
list.
shall be kept in
For
avail-
the time being, full list. For the time being, the order dated 23rd January December 2025 be kept in abeyance. Kept in abeyance. Full list. ऊपर में ना एक जगह हमने बोला ना, petitioner has prayed for
27th.
the learned ASGI submit that this court is not having the.
My lord, may I?
कर देना. The ASGI further submit that the petitioners have executed the alleged to have been executed the work under the agreement between the state and the petitioner, and the central government is not the party. I recorded the submission.
My lord, may I pray
Lord,
one
may I
thing,
take
my
back
lord?
the order. Last order I have handed over about the area payment order.
My lord, may I
Take
pray?
back-
My lord, may I pray one thing, my lord?
Yes.
May I take back the order
Yes.
which handed over to your lordship on only in respect of the area, the last order of the division bench. Maintainability question raised and all that. May I
Yes,
take back
that
that?
I already recorded.
No, may I take back the order handed over to
This
you?
order has been
You hand it over to us.
by the state.
us.
That
I have given to your lordship.
No,
already
you take
written.
back.
My
You take
copy.
back.
Acha, last order.
Not that. I have, that is about the 18th June order I have taken back. The other order, division bench directing the question of maintainability as regards payment of area is kept open, direction for affidavit. Just now I handed over the second document.
7 November.
Yes.
My lord, may I pray one thing, my lord?
Yes.
My lord, the application copy may be served advancedly, my lord.
Let come
My
before
lord,
this court.
so okay, so that we can peruse, my lord. Otherwise, my lord, on that day, my lord,
Correct,
again.
madam. Let the same be come before this court. Then I will, if required, I will serve. I will direct. Let the court ascertain what is
Yes,
the
your lordship. Yes, your lordship.
That scheme is funded by the central government.
I already recorded your submission. I am not deciding anything. What are the submission? I have not recorded anything on finding. Thank you.
By any way, central government will come.
Correct. Central government is our father.
Yes, your lordship. Grateful, your lordship.
Yes, call the next matter.
My lord, the prayer is same as my lord, item number 6, my lord. My subject matter of the writ petition lies with the group 6, my lord.
What?
Inadvertently. What is it? My lord, enhancement of remuneration.
Huh?
Enhancement of remuneration.
That is a statutory matter.
Enhancement of
Remuneration.
remuneration.
Yes, my lord. Of my lord, we are, my lord,
Working as?
working as my lord, multitasking staff and my
Why
lord,
here?
Not here.
not here, my lord.
Staff of a mosque.
Mosque paid by the central government, my lord.
This will go before group 6.
Group 6.
Go. This court find that this court is
If
not
be
having the
granted, my lord,
determination
correctly,
to
my lord,
hear the
presentation
present
form.
application accordingly. WPA number so and so is released from the list of this court with the liberty to the parties to mention before the appropriate court.
And a leave may be guaranteed,
The
my lord.
petition is given liberty to correct
Presentation form.
the group number in the presentation form in course of the day.
Deep location.
Next.
Item 9 is my application unit by my lord's order of 3rd December 2025.
Item 9.
Yes, minute.
Yes.
So this is that matter of trolleys and stalls, minute. Minute, by my lord's order of 3rd December 2025, minute was pleased to grant me an interim ad interim order, minute, till 7 January. Minute, the order is expiring tomorrow. Also, minute, by this order, minute, had directed them.
Today we are on 7.
Yes, minute. And minute, my lord had directed them to file an affidavit. No affidavit has been forthcoming. The applicant will kindly have a look at paragraph number 9 of this order of 3rd December, minute. It has put a specific question upon them last 4 lines or at page 3. The authorities have passed the said impugned order by relying upon the letter dated 23rd June 2023, but it is a specific case that the letter was not served upon the petitioner. The respondent authorities are required to disclose the said letter on the basis of which impugned order is passed. But till date, there is no service of that particular letter or an affidavit of opposition.
But I have already filed a
Yes, Lord.
vacating interim order even with service to all. I have tried to mention before your lordship before vacation, Lord, to include that matter being included.
That failed.
I have.
But we have also taken out a contempt application.
Unsuccessful. Usually that done.
No, my lord, we were successful, but for whatever reason, it was not there in the list. My lord.
This matter be heard, Lord. The evidence are also ready, my Lord.
Not read, not served upon us. We will have a
When
chance to
affidavit-
deal.
Serve the affidavit when you will serve.
Okay. By tomorrow.
Tomorrow or day after tomorrow. I am giving
affidavit is
affidavit in opposition is already ready, my Lord. But
okay. I am extending 1 week time to you.
yes,
1 week time to them. So I am fixing a specific date for the hearing.
Yes, but will in the meantime extend the interim order. Also, Millet, we have preferred a contempt application, Millet. The contempt application was in the list till yesterday. With the contempt being, Millet will kindly have a look at the order, the paragraph 10.
So what is the contempt? They are not compliant.
They
with
have
it?
not complied with, they have not allowed me to operate.
next week,
They have not allowed me to operate this stall. My commercial business is at peril.
You can stick the date.
Okay, I will take.
But then the intention of getting this order, Millet, has been subserved, Millet.
But see, the order is to be complied with.
Yes,
Tell your authority.
When will this, sir?
Tell your authority once this court will find and that you are not aware of my with 2 points with regard to the suppression of fact, with regard to the violation of the order. This court is having
This
some
court is
other.
really
We are the
strict, Millet.
officer of the court, Milord, we know.
This court is having some other
Yes.
intention with regard to the two things: suppression of fact and violation of the order.
Yes, that's it.
The counsel for the respondents press for extension of time to file affidavit in opposition. Counsel for the petitioners press for extension of the concerning the submission made by the counsel for the parties, time to file affidavit in opposition is extended for a further period of 1 week. Reply, if any, there to be filed within a week thereafter. Interim order is extended. Date the दिन, especially fixed date दिन. भी है कोई देखो दिसंबर की जनवरी में 28 and let the क्या बोला is extended till 28th of January
21st, Milord, your lordship can
28 January.
Deeply obliged.
28, 20.
28 28th of January at 12 noon as a specially fixed matter.
It will kindly also record that
The
in the
interim order,
meantime.
interim order is extended. The interim order is extended till 3rd of February 2026 or until further order, whichever is.
Also, Millet, with regards to Millet, them allowing my.
Bring all the.
But even the contempt Millet shall appear because scan is appearing today, but the
It is
contempt
submitted by
application
the
is not
party.
appearing.
It is submitted by the respondents that the respondents have filed an application for vacating the interim order being can number 1. Can number 1 of 2025 or 26? 2025, and the petitioner has filed an application for violation of the order
Being CPAN number
CPAN number
2033 of 2025.
033 of 2025. Let both the application be placed before this court along with the writ petition on the date fixed.
Deeply obliged.
Next.
Milord,
For the respondent bank, my lord.
Milord, this is the matter, Milord. This is surfacey matter, Milord.
Relating to surfacey, my lord.
And that is
Fixing it. Surfacey matter.
surfacey matter. And Milord, that is the reason I have mentioned yesterday for.
I'm releasing it.
Yes, Milord, let this matter be placed before the.
I am releasing you, ma'am, with the liberty to mention before the appropriate court having determination. And it is submitted by the land counsel for the parties. The matter is connected with the Surface Act. Accordingly, WPA number 27545 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination. Next.
Lordship, in item 11, I'm appearing on behalf of the petitioner. Yes, Lordship. What has happened in this matter?
Having the instruction.
Lordship, I'm having the instruction. Lordship, may I apprise your Lordship that the petitioner was a bona fide purchaser of 100 equity shares from the Brazilian Industry Limited. And thereafter, after compliance all the procedural formalities, the name of the petitioner was never appeared in the member list of the register of companies. Thereafter, petitioner.
So you want to withdraw?
Yes, why I am withdrawing, Lordship?
Not necessary. I am not recording any. I am only allowing it. You want to file a fresh?
No, Lordship. What happened? I approached the SEBI, Security Exchange Board, for seeking information on the RTI Act. And after filing this petition, I came to know that the reply which I was seeking through the direction of this Honorable Court has already been given. So therefore, I am withdrawing, Lordship.
The matter is listed as to be mentioned on the prayer of the petitioner for withdrawal of the writ application. The counsel for the petitioner has handed over a communication dated 12th of August 2025, wherein the petitioner has informed the petitioner for withdrawal of the writ application. Consider the submission made by the counsel for the petitioner, peruse the communication dated 12th of August 2025. The writ petition is dismissed as withdrawn. Dismissed as withdrawn. The communication dated 12th of August 2025 be kept with the record.
Deeply obliged, Your Honor.
Next.
But I'm extremely sorry and my lord, so embarrassed that I've come with this matter before your lordship. My lord, I'm extremely sorry.
Lordship, kindly consider my lord's order.
My lord, I shall take your lordships to that order, my lord. My lord, this is an application for praying for recalling or modification of your lordship's order, which has been passed on 2nd of December 2025. My lord, what happened in this case? This petitioner is a housewife. My lord, a complaint has been lodged by respondent number 8, who is the father-in-law of this petitioner, before the Maintenance Tribunal, SDO of Kontai, under Maintenance of Parents and Senior Citizens Act. And my lord, an order was passed therein. It will take a detailed copy, 100 page. My lord, if your lordship sees the page number 100 of my writ application, there, my lord, the order was given in this manner, my lord. My lord, kindly comes to, I'm reading, my lord, kindly hears me. The SDO Kontai, he has passed an order, page 18 of main application, writ application. The opposite party, Badshah Maiti, admitted the fact and stated that his wife misbehaved with him. Priyanka Maiti, the spouse of Badshah Maiti, Priyanka Maiti is the petitioner herein, informed to the court that now, my lord, the SDO passed such order. The petitioner was facing a huge financial crisis and the property in question was about to auction. In that situation, she and her father stabled the circumstances by financial help. The Mugberia Cooperative Bank was not approving any loan until and unless whole property shop was not fully transferred in the name of Priyanka Maiti. Now, second, she is a mother of 2 daughters, child, who are unfortunate enough to get any assistance from their father or grandfather. The future or security of 2 girl child is nothing but this land. This court also perused the deed of gifts. My lord, what happened? Father-in-law, respondent number 8, transferred a property in the name of the husband of this petitioner. Husband transferred that property in the name of this petitioner. Thereafter, my lord, father-in-law, he moved an application before the SDO Kontai, as that is the maintenance tribunal. Now, my lord, the SDO passed an order. Hence, this court orders that all members, that is Priyanka Maiti, her husband, father-in-law and mother-in-law, will stay at their residential house without any condition. This cannot be, my lord, number 1. Number 2, the petitioner Abhay Chandra Maiti may start again his business at the shop which was gifted to Priyanka Maiti, and Priyanka Maiti is restrained from creating any obstruction with the premises related to business. As the deeds are unconditional, the petitioner prayer for cancellation of the deeds is not considered by this tribunal. Now, the fact is, when a deed was executed, there are other forums to cancel that deed. Now, SDO passed an order. Now, my lord, what happened? A writ application was filed. But, my lord, the conducting lawyer, my lord, probably in his by his inadvertent mistake, or my lord, as my lord, in his based wisdom, he, though filed a writ application, he withdrew that application. My lord, kindly comes to page 12, your lordship's order.
That's why I have gone through.
Yes, my lord, fact is, my lord, there is a appellate provision or appellate forum only for senior citizen persons. But
No, that has been clarified by the subsequent, the other.
my lord, I have annexed a division bench order, my lord, in page 14 of this honorable court. This is division bench order. My lord, before reading from that order, my lord, if he is the victim or my lord not a senior citizen, then for her or him, my lord, writ is the provision.
No, because
My lord, I'm showing, my lord, I'm showing. But my lord, if he is a senior citizen, then my lord, there is the appellate provision. Now, my lord, I shall take your lordship to page 14. I have annexed, my lord, the division bench order of this honorable court.
Correct.
My lord, relevant paragraph 9 of page 17. I'm reading, my lord, I'm reading. On a bare reading of section 16, I'm placing the book, my lord, before your lordship. On a bare reading of section 16, this is section 16, appeals.
Yes.
Yes. Any senior citizen or a parent, appeal 1. 16.1. Any senior citizen or a parent, as the case may be, aggrieved by an order of a tribunal may, within 60 days from the date of the order, prefer an appeal to the appellant tribunal. If he's a senior citizen,
Correct.
but father-in-law could have preferred, but she is the daughter-in-law.
Correct.
Provided that on appeal, the children or relative who is required to pay any amount, so and so, so and so. On receipt of an appeal, the appellate tribunal shall cause a notice to be served upon the respondent. Thereafter, my lord, kindly comes to page 17 of my application. I am reading. On a bare reading of section 16, it appears to us that the right of appeal has been conferred only on the senior citizen or parent, as the case may be, who is aggrieved by an order of the maintenance tribunal. The wording of this said section is absolutely clear. There does not seem to be any scope for confusion. The legislature, in its wisdom, has restricted the right of appeal under section 16 to the senior citizen or parent. So, my lord, only provision was given to this.
You are having the order because I
Yes,
have
my
got
lord,
an order.
this order.
Otherwise, you give me some time. The same thing was with the court observation is only a senior citizen, but in one matter I decided the one judgment has been placed before this court. No, it has been clarified.
But the order is in page 12. Oh, no order.
Not another
Another order. All right. I shall.
So I am to pass. Let it become next week.
My lord. I shall also, my lord, prepare myself, my lord.
You also search it.
Lordship.
There is an order of the whether it is a division bench or single. If it is a division bench, then it has to be referred.
Yes.
If it is single bench, then I have to follow the division bench order. Because the very first when I have taken this matter, this the same thing and a senior citizen, but the judgment was placed before this court. No, the court has interpreted. Not by this court, the Punjab and Haryana High Court also interpreted.
Yes, my lord, there are other interpretations from other honorable courts also. My lord, shall I read, my lord, for our satisfaction? Or my lord, we shall search and thereafter come on.
That is better. If it is single bench, then I have to go by the division bench. If it is a division bench order,
my
then
lord,
I have to see
I bow down before
whether
your
it has to
lordship,
be the court has to go by this or it has to
my
be.
lord, I bow down before your lordship. My lord, I was so embarrassed, my lord. But my lord, I got an opportunity of studying this subject, my lord.
Good subject.
Grateful, my lord.
Let the matter appear. Let the matter appear on 15th of January.
15th of January.
Under the same head.
My lord.
15th January under the same head.
Grateful, my lord. Grateful, my lord.
Take the book. एक पे काम करिए हमको मेरा चैम्बर में भेज.
Grateful, my lord.
Next.
Well, I am for the petition in this case. Lord, on the last occasion, I submitted before Lordship that I am very old, about more than 104 or 5 years. And he is in the deathbed. In fact, after having adjourned this matter, my client has renounced this world. After the death of my client, I have filed an application by the heirs of my client for substitution. But even I have not yet received the death certificate. And in spite of that fact, stating the date of death, I have filed an application for substitution so that after being added, your matter may be hard. Or else, if your lordship said.
No, but without, if they are admitting the death, then it's okay. If they are not admitting the death.
That is not the question. I have a firm question of law to submit.
If, then the merit of the case is to be taken.
No question of merit. Whether the local standard to file the application, that I am submitting. First of all, only remember 3 points I asked. One, the certificate, secondary evidence certificate of R.N. Giri, that is in question.
That is in question. Yes.
Second, limitation following the Constitution Bench judgment, 64 Supreme Court, he submitted. It has been overruled. And he will produce that. On that ground, your lordship was trying to keep it under CAB. He submitted. No, I shall produce the judgment. It is overruled by the Constitution Bench, larger bench. Number 2.
Yes.
Number 3, it is an admitted case that the applicant Vishnupada Jana, that is below an application which was made on 24th of July 1986, page 52. And this writ petition was filed on 19th November 2025. Admitted case is that pension was not paid. He is of 104 years of age, what he is submitting. Now there is a death. He is submitting death. And on that ground, he is asking for substitution. But the scheme provides, if the applicant who was a freedom fighter dies before grant of pension, the other legal heirs and his stock, he will not get any pension. Therefore, this is not maintainable at all. It is infructuous, not only on the ground of merit of limitation of the 64 Supreme Court. I am giving to your loss in the scheme.
Yes.
Scheme.
Well, my learned friend complete. I will argue each and every point. The first point my learned friend has said that the writ application is barred by limitation.
Yes.
In,
What is the judgment?
In view of the decision
Just a minute. Yes.
as reported in
judgment.
1.5. Oh, 1.5 of the guideline. 14 guideline. Sanction of pension after the date of freedom.
Yes.
No pension shall be sanctioned in the name of the freedom fighter after your hard test. If your hard matter was that you like time areas of the sanction, either or house daughter after
And that upon an additional question, your lordship is aware, your lordship has time and again said us that if the applicant originally does not mention the name of the nominee, whether this application for substitution is absolute.
Yes.
Like here, I am not asking the pension by the heirs. I am on the petition of my father. My father paid for the pension. He moved this application here. The first point is whether it is barred by limitation or on the score of the limitation, it should be rejected. My learned friend has referred the judgment of Hilal Bhai judgment, reported in 1964, Supreme Court, page 1006. My learned friend says there is a limitation for filing of the writ application, 3 years. Their first point is it is barred by limitation as per the decision of the Honorable Supreme Court reported in 1964 Supreme Court. In the case of Hilal, I know my learned friend is quite aware of the judgments of the Supreme Court, so not I am, as my learned friend. It is fact that the judgment has been set to the effect. In fact, we are sorry to mention that judgment is not a good judgment. In the subsequent judgment of 1997, 5 Supreme Court cases in the case of Mafazlal, paragraph 70. Well, I am referring the judgment.
এখানে নয় এসএসসি তে আপনার যে সুপ্রিম কোর্টের যে 70
তাহলে সেটাই দাও।
এটা দিন আপনি আমি দিন এটা দিন আমি দিচ্ছি আমি ওটা দেখে দিচ্ছি আপনার এটা স্যার
Lord, your lordship can have a look to that judgment. It is a constitutional bench or full bench by three-bench judgment. But I'm placing this first. I got so many cases of this High Court, even including my lord's judgment. I will refer one by another. Kindly allow me to some extent, especially for the reason I am today to some extent handicapped because I have forgotten to bring my spec. So I may be in difficulty. Kindly excuse to that.
You have a difficulty, you take time, not.
I can read, but slowly.
The court will not give the trouble to you without the specs. You can go, you read. You take time, no problem.
No, I will not.
Come with your
Lordship,
specs.
kindly say, I am not in that habit of taking the time. I will do that.
No, if you have any problem, no problem.
But not very fast.
Okay.
Kindly excuse to that effect. Lord, your lordship has seen paragraph 70.
70 এখানে আছে
Paragraph 78.
78 হবে 78
Paragraph
it starts with the D.
My lord, that judgment is 78. My learned pen says paragraph 78. কোনটায়?
এইটাতে দেখান না স্যার অসুবিধা হবে না ওটাতে দিচ্ছে না তো আমি তো দেখতে পেলাম
কোনটা দিচ্ছে?
এইটাতে দিন এখানে দিন না এটা সুপ্রিম মেজিস্ট্রেট রিপোর্টেড
But if that be so, if that be so, if the limitation be ignored, then now we will come on another other point. As my learned friend has raised the point of limitation, we have to satisfy my lord about the limitation.
Limitation also with regard to maintainability also. You
Maintainability on the ground of the guideline of 14.
Correct.
Well, then my lord, I am no need of arguing the maintainability of the writ application on the point of limitation.
No, I am compelled to interfere.
Both.
The question of
But
sustainability
let us look at the limitation first.
The question which is raised, Lordship is aware, under the provision of Order 14 Rule 2 and Order 7 Rule 11, preliminary issue as continuation of the proceeding which have become brought to us, and it will be an abuse of the process of court. If you answer first that, then you shall go to the merit.
এটা একটু আমাকে দিন আমি বার করছি
You should ask answer first, so that the substitution application is maintainable at all. And particularly when no mention of application.
Mr. Manna, first of all, you filed an application for substitution. How the substitution is maintainable? Once the substitution is allowed, then only the writ petition will come. How the substitution is maintainable now? Because original already died, wife filed an application, wife died, now the children wanted to become the petitioner before this court. How it can be?
To that effect, your lordship will remember one writ application was moved before the Honorable Court before the single bench. When by the wife of the freedom fighter, original freedom fighter. Lord, he applied, he died, he did not move. Thereafter, wife Debola Bala Bera applied. In that matter, one of the single bench will not dismiss on the ground of delay. I have brought that judgment. I will hand it over. But in that judgment, after dismissal,
Mr. Madam, you do one thing. What are the judgments you relying upon? You made a compilation, give to the other side, come with the ready so that matter can be
Supreme Court. They have lost in the Supreme Court.
Their matter is
no.
They appear.
So that's why give the what are the judgment, you give the compilation with regard to this. This first is the limit, first is the substitution, second is the limitation, third is the legal. These are the three points.
Regarding limitation, I have made a compilation.
Correct.
I can hand it over here and now.
Correct.
Regarding the point after the death, whether it is maintainable.
Correct.
To that effect, I am saying in a matter, in the case of the Debola Bera, after the death of Debola Bala applied, he came after a long period of time, so the single bench dismissed. Against that judgment, an appeal was preferred before the division bench on this court. Wherein, by an appeal, it has been decided, may not have a look to page number 5 of the appeal court judgment. Well, I am coming to the maintainability of the heirs subsequently because subsequently heirs were substituted.
That's why I'm coming. What is
So,
that?
so
Why
my
you
lord.
give the compiler?
Why
Let's
it is
say
like
the
that?
other question.
And it has been appealed by
One by one, you are giving one judgment. You are giving give the compilation.
copy
the
down.
other side compilation to the court.
Why I am handing over a copy? No problem. my lord.
Which paragraph?
Page 5.
না আমি প্রথম থেকেই দেখিয়ে দিন
My lord, your lordship kindly first page number 1. Read application, last paragraph, read application dismissed by Honorable Justice Dipankar Dotto when his lordship was here.
লিমিটেশন
Then your lordship appeal was preferred. In the appeal, your lordship will find the finding of the court division bench at page 5. Right. Running page number 5.
রানিং পেজ 5
There is no running pages.
The first, after 2 lines from the top.
Inner page.
Running page
Inner
number
page 2.
inner page 2
Inner page number 3.
3. Paragraph 1.
It has not been paragraph number.
Not paragraph. Therefore.
Therefore, the applicant was entitled to apply for Swatantrata Samman Pension 19 scheme. The scheme which is being considered by us not an ordinary scheme, but postulates to freedom fighters pension scheme, and it is only in this
scenario
scenario that the court below ought to have considered and passed the order dated such and such, and
in not
doing so,
as mentioned
stand herein above, the order dated such and such
cannot be sustained
and accordingly
calls
for interference by
and
this court.
set
So delay was
Conduct.
ignored and ultimately refer the matter to the single bench.
স্যার স্যার এখানে বলুন যে এর এগেইনস্টে ওরা কোনো অ্যাপিল করেনি দ্যাট ওয়াজ এগেইনস্ট
Against this order,
হ্যাঁ
so far my knowledge goes, no appeal was ever preferred. They have accepted this order.
they are a single
Then your lordship's matter was come to your lordship before my lord's court. At your lordship's judgment
This order?
starts at page number 7.
Connecting with this matter.
yes matter
Not this matter, but identical matter, the point raised by the heirs. This matter came before my lord at page number 7, running page number 7, and your lordship's finding will be
9
at page number paragraph 30.
স্যার ওটা ওটা লিমিটেশন আর হচ্ছে 9 এ হচ্ছে ওটা 1.5 অলসো
কোনটা
9 এ প্যারাগ্রাফ পেজ 9 এ 1.5 টা কভার করা আছে আর পেজ 10 এ হচ্ছে লিমিটেশন দুটোই কভার করা আছে
paragraph 30 covers the limitation.
30 না প্যারাগ্রাফ 26 9 টাকে দেখান
Inner page.
9
Inner page 9.
9
Page
1.5 it's 1.5
Paragraph 27.
26
Page 9.
হ্যাঁ
Paragraph below 26.
it's 1.5 sir regarding
Page 9.
Yes, 1.5 was taken into consideration.
yes
My lord consider. Then my lord consider at page 30. Sorry, paragraph 30.
point of limitation
Point of limitation.
that was also considered
And during pendency of that writ application, my lord, the Debola died. My lord substituted his sons in the writ application. My lord allowed the application directing the central government to pay the pension to the petitioners, the substituted heirs of the Debola, from the date of the application. Against that, my lord, appeal was preferred. 2 sets of appeal was preferred. One by us, another by them. But in our application, we pointed out the sons cannot have the pension, but they are entitled to have the area of pension of his mother or father.
lifetime
My lord, in that application to appeal, my lord, the appellate court agreed with our proposal and modified my lord order to that effect. Pension from the date of area of pension, that is the lifetime area of pension of the father, will be paid to the heirs, that is sons and daughters of the deceased Devolawala. Against that order, they prefer an appeal before the Honorable Supreme Court.
স্যার পেজটা একটু দেখিয়ে দিন পেজটা আর ওদের অ্যাপিলটা ডিসমিস করেছিল
Their appeal has been dismissed.
দেখাচ্ছি
I'm just referring.
স্যার এটা দেখুন 11 দেখান
Paragraph 11, page 11.
পেজ 8
Eight, sorry, my lord. Sorry, my lord, page 8.
প্যারাগ্রাফ 11
Paragraph 11. Their appeal was not dismissed.
Yes, gone through.
10 থেকে 10 and 11
Lord, my learned junior is saying to the first
10 and
paragraph 10.
10 and 11
10 and 11 both.
Yes, I have gone through.
দেখেন 10 and 11
No, no. Division bench, their appeal was dismissed. Our appeal was allowed, and my lord's order was modified to the extent the lifetime area was paid to the
legal heirs and
substituted heirs.
So now you got the pension.
yes
You got the arrears.
Yes, I am coming. I am coming.
again sir the challenge is
They challenge this matter before the Honorable Justice, Honorable Supreme Court. Your Lordship find at the last page of the bunch.
Yes, not inclined to interfere with the impingement.
They have lost. Subsequent to that, they have paid the entire area of the father.
Yes.
So, my lord, it has reached this finality. Now they cannot raise this point. This is my short summary on the point of 5.1.
Got it. Next.
Next is question, if your lordship do not point here on the point of the limitation, I can raise the other decisions of this court also, where there was 21 years delay, in the Supreme Court 31 years delay. I have brought a compilation with me also.
sir
Can I hand
লিচু वाला थोड़ा execution main judgment paragraph 16 voted judgment
Millard, before handing over, I like to hand over another judgment of this
Computation.
on the point of the limitation.
paragraph 16
solo. Millard, if your lordship come, Millard, paragraph 16, for a moment, your lordship will find the one of the division bench of this court, Millard, has considered the delay point.
Yeah, they already given. The last yes. Paragraph 16.
Paragraph 16, 1-6.
Yes.
In the compilation, I have referred 10 judgment of the Supreme Court. But if you are short, I know, my lord knows it, all the judgments. For your my lord's assistance, I can hand it
This
over.
court doesn't know anything. We are learning from you only.
We are not so. I am not so educated as my lord and my learned friend is. Lord, I can hand it over the entire.
That's why this bunch.
Lord, I am handing over the judgments which has been Millard mentioned in the compilation, just hand over by me. I got a compilation here. Well, can I and with a request to my lord, my lord will kindly ignore the marking. But it is my compilation, so I have marked to.
This court is not having the mind to mind it.
I am giving the reference. I am giving the reference. I am giving the reference.
Reported judgment.
So all are reported.
they have appeared
Unreported is there.
No. I have given all the reported judgment of the Supreme Court.
Give the compilation.
To that, my lord, can I take the one so that can the reference? It's a but I am giving the reference. No, I take another. I can take a reference.
আজ আমি রেফারেন্স করে দিচ্ছি রেফারেন্স
But I am giving the note to my lord.
আমি রেফারেন্স করে
Even I have given the note. Reference
you
from
give the copy?
on the last day.
You come.
I have handed over to your junior. On the last day, my lord, they asked for.
Go through the judgment and come on the next day. When?
যারা সাবস্টিটিউশন অ্যালাউ করবে কিনা সেটি জজের ডিসাইড।
আচ্ছা
division bench judgment
Another point is pending of the Supreme Court cases. I have that. Lord,
Mr.
to that effect, Lord, what I am on.
Mr. Chakravarti, this judgment you have given, this one, which you have given to.
But Bank, yes,
Given to.
This is actually not reported judgment.
Not reported. That's why the copy has been given to you.
Yes, copy is 598 W of 26.
Please see, there is a my judgment.
Reference
Subsequently, kindly come to the second one. Then there is my judgment. I have condoned the delay.
entire bunch I have given up to Supreme Court.
Rely on this which is supplied to us. I have no objection.
No,
If anything unreported he wants to rely that as in the compilation, that has to be handed over to us also.
No, I don't think all of the reported judgment, that is 1964, 1997, 1980.
64 is their judgment, my lord, not my judgment. They have not given a copy out to us.
Good. All the
They have
reported
not even
judgment.
given us that.
Give the copy. This
No,
this
I
I am giving them. No, I am,
he did not give us the entire compilation. He has possibly made a list.
that this copy
List.
you. Give
List.
this copy.
Yes,
I'm
list is given.
a copy, my lord.
Give this copy to the other
I'm
side.
having it
You're not
Xerox.
having the copy.
এটা জেরক্স করে দিতে হবে আমার কাছে আর কপি নেই Well, I will have it Xerox.
You do one thing, get it Xerox and give to my court officer.
Yes.
And to us also.
Oh, no.
Yes, your copy be given to the ASGI. You take this, get it copy and give to
I am having it Xerox, handing over to my
Yes, give
junior and handing over lastly this copy to my lord's officer. In course of
in course of the day. Recorded. Learned counsel for the petition has concluded his
After any day after 27th January.
Learned counsel for the petition has concluded his argument, full stop, and have also relied upon several judgments. Full stop. Citation has been referred given to the learned counsel for the Union of India. Learned counsel for the Union of India pays for time to give reply. According cases adjourned, let the matter appear on February first week. में देखो. Fourth February at 12 noon. 4th February 12 noon.
4th February
12 noon.
ঠিক আছে
As is fixed matter.
February থাকবে no will be lost the present record and maintainability issue
The issue
of change circumstance.
The issue raised by the petitioner by the respondents with regard to maintainability of the petition is kept open.
But in that event, can I not pay whatever they will defer prior to a copy or to us so that we can not take exception of that?
Let come on that, they will see to that.
My lord's time will be.
Yes, next. गाइडलाइंस उसमें गाइडलाइंस है वापस कर दो वो नहीं एक गाइडलाइंस है वो नहीं है वो वाला ये है ये
In that event, all the judgments and the compilation I will hand over to my lord's office.
Next. Call.
May it please your lordship. My lord, this writ petition has been filed selling a decision of the fire department. My lord, what happens? This is a flat owners association, which are the petitioners. My lord, these are high rises. So my lord, gas cylinders are not supplied. There is a tank where the gas is stored, and through pipeline this gas is. So my lord, we have been using this since 2006. We file an application for renewal of it. Your lordship will kindly come to page P6, annexure P6 at page 44. Page 44. My lord will kindly see the date of the application.
Fire license.
Yes, my lord.
Yes.
Which is a necessary ingredient for storing that in that gas. Now, my lord, without even hearing, without giving me a show cause or anything, it's been running since 2006. Thank you. 54 flat owners are concerned. My lord, kindly takes annexure P11, which is at page 65.
Page 44 is the application.
Yes.
Manoj Agrawal.
Yes, my lord. One of the.
This is the application. Yes.
One of the My lord, now page annexure P11 at page 65. My lord, will see status rejected, date of rejection 21st of November 2025. No reason assigned, no hearing given, nothing. Absolute violation of natural justice. Something which has been running for the last 19 years. Why suddenly they will not do it? I know why they will not do it, because there is a troublemonger amongst us. One rotten egg in the basket, which is the private respondent. This is a private respondent. But will kindly see the number of cases this gentleman has been filing. Your Lordship looks at paragraph 9 at page 7. A veteran litigant, good for lawyers to have client like this.
Yes.
Fortunate. Manoj will kindly see from page 9 to page 12.
That too, Mr. Bhattacharya.
No, not
Because he has to defend. Defend.
No,
Yes.
So, my lord, what I was beseeching before your lordship, my lord, this rejection be set aside. Let them give us a hearing, and in the meantime, let them not take any coercive steps. My lord, 54 families.
Who is the authority?
My lord, I am happy for state of West Bengal, my lord.
Who has rejected this?
My lord, the fire department, which would be, my lord, the respondents 2 and 3.
Applying for.
Huh?
Respondents 2 and 3.
You are for the fire department.
Yes.
So, yes, what is your submission?
They have annexed a document that kindly come to page 28 of the petition.
Page 28.
Yes. There are certain recommendations proposed by us so that it can be complied with before issuing that. But that document is in 2023. But there are another later also. There are certain recommendations that before renewal of the license, these recommendations should be complied with.
Correct. Whether you have informed to them.
Yes, yes.
Where is the letter?
I have got an instruction, kindly see. There is another letter of 2025.
After this, they
Kindly
extended till
No,
September. This is 23.
kindly page 1.
Page.
Who is Devraj Datto?
He is advert on record. Right?
Nothing.
This is my instruction.
This is a building for the file is different. Fire license is different than gas bank. They have annexed everything. Building is
Yes,
Will kindly come to page, the document of 11 June 2025. The first annex, annex, I understand. Yes. Recommendation 2023. Thereafter, this letter was written by the fire department to his advert to his client. Kindly go.
This is not a fire gas bank. This is for the building.
Well, it is fire department who will take that. And it is in the next document.
Yes, 10.
10 times.
Correct.
And the recommendation of 2020, which they have annexed at page 28, I have also annexed. So these recommendations should be completed. It's a fire department. It's very, who will take that.
Mr. Bhattacharya, your client has received the letter on 11th June. Kindly
11th June.
11 June letter. Authorized signature.
No, not only the recommendation of 2023, 2025 also up to date amendment. They have not carried out that.
Malad, may I submit? Fire license is different from a gas bank license.
Do one thing.
One document, may I just show? My learned friend showed page 28. Malad kindly takes page 32. Kindly takes page 32. That 32. Page 28 is a document of 2023.
Correct.
This is page 32. Malad, this is that gas bank license which they themselves have renewed on 11th of February 2025.
Yes. Because this recommendation of 2025, each time the renewal has been made either 2 years or 1 year. 2023, if I renew for 1 year, it will exceed the recommendation period. You have not complied with the recommendation.
What is this page 32? What is
Yes.
the period?
My lord will kindly see from up to September 7 September 2025.
That's 2025.
Yes, from 8 September 2023, retrospective effect
Correct.
in respect of the aforesaid license.
Correct.
This gas bank.
This is his gas bank. This has nothing to do with this letters, which is a general fire safety license required for a building. These are completely separate and distinct.
Gas lines. If any fire hazard is there, then you have to give the equipments of the fire.
Yes, all equipments are installed.
Subject to correction. What I propose, if both the parties are ready, let the fire inspection give a notice to the petitioner, inspect the premises. No, I am pending writ application.
Yes.
Give the date, or this court pass the law, will fix date and time for inspection of the premises and notified what the things are required to be done. Notify the petitioner, and the petitioner will rectify the same within 2 weeks. And
If anything needs to be rectified.
No, if anything that needs to be rectified.
The petitioner, if anything is required to be done by the petitioner will complete the same within 2 weeks and let the file them after 2 weeks.
Unless they rectify
Within 1 week, the fire officers will inspect the premises and inform what are the things is to be done. And if it is done, if it is required by the petitioner will complete the said requirement and let the matter appear after 3 weeks.
Grateful. Violation of natural justice, Walpole. He doesn't want the gas line, so we can ensure that his line to his house is, my lord, severed.
This court is not up to that technical.
In accordance with West Bengal Fire Services Act 1950.
Who is the authority?
2 and 3, my lord.
No, inspection.
That would be my lord 3.
3.
3, yes, my lord.
Yeah, record a note.
Well, kindly consider the later date 11 June 2025.
I am not considering. I am simply directing the respondent number 2 will inspect which date? Respondent number 3. Which date and time? Tell me.
Well, that I cannot say.
Because why I am fixing the date and time tomorrow? He will
upon intimation to us.
No, that's why they will not say the notice has not been issued. This court will fix the date and time so that both the party can be present. Correct. The petitioner has filed the present application. On rejection of the application filed by the petitioner for grant of renewal of fire license. No,
for the purpose of gas.
For the purpose of
gas bank license.
Gas bank license.
Gas line license of the building in question, or the premises. What is called?
The Tirumani Apartments, my lord.
With regard in the apartment of the petitioners. The learned counsel for the petition submit that the petitioner has made an application on online application on 30th of July 2025, but without giving an opportunity of hearing, the application was rejected by the authority on
21st of November
2025. Learned counsel appearing for the state has submitted the report and submit that for the prevailing guidelines, the divisional fire officer has communicated a letter to the petitioner signatory of the Flat Owners Association on 11th of June 2025 for making necessary
13, 14,
to complete the discrepancies as mentioned in the letter dated 11 June 2025. But in spite of receipt of the said letter, the petitioners are not cure the discrepancies as noted in 11 June 2020. Subsequent on 10th of October 2025 also, the Divisional Forest Officer has sent a notice to the legal advocate of the petitioner, but in spite of the said, no application has been submitted, and finding no other alternative, the application of the petitioner. This court find that dispute the presented application for non-providing the fire license. Non-providing the fire license for supply of
Gas bank.
gas line. Gas line. The petitioners
Progress.
on the contention of petition, then no opportunity is given to the petitioners, and the application of petition is rejected. The respondents' contention is that the respondents have made has requested the petitioner to cure the discrepancy, but they cannot cure the. Considering the above, this court find that the divisional fire officer, that is the respondent number 3, shall inspect the premises in question on
13th, 14th any day. 13th, 14th any day.
On 15th of January 2026 at 11:30 a.m. AM, and all the concerned persons shall remain present at the time of inspection by the respondent number 3 for grant of license to the petitioners for supply of gas connections. For grant of fire license for supply of gas connection. Full stop. If at the time of inspection by the respondent number 3, find any discrepancies for grant of the fire license, the same shall be immediately within 2 days informed to the petitioners in writing, and on receipt of the same, the petitioners shall cure the discrepancies within a period of 1 week.
Discrepancies,
if any, shall cure the discrepancies, if any, within a period of 1 week.
Within 2 weeks.
Within a period of 2 weeks thereafter. Full stop. Let the matter appear. 2 weeks, bola na. Let the matter appear on 9th of February 2026 under the same heading.
Only one submission, admit, only one submission. Before inspection, they should comply with all the requirements as stated in later dated.
That's why that's a dispute. That's what I'm telling. Let me
We have done it. We have done it, my lord. The annexure.
That's why let me inspect. Let me inspect. All concerned. All concerned, including the private respondent. All concerned person, including the private.
Who advocate? Including his advocate.
Mandatory should be present.
9th February, Next.
9th February. Matter will appear 9th February.
Yes, 9th February under the same heading. Yes.
My lord, my application, my lord, for amendment of the writ petition, my lord, the state.
My lord, and my lord, I'm vehemently opposing this amendment application is drastically, my lord, changing this very
No, my
basic,
lord, it does
reading
not.
of the petitions. First of all, the petition was, my lord, against that state of West Bengal. Certain deliberately they suppressed all notifications. They everything they have, my lord, relied on. Only 7 except this one. When we came up with this particular, the center's notification, which is meant for all other states in India, including the union territories. Now it is better to, my lord, to learned senior friend to, my lord, clarify that. It is, can it be applicable?
Yes.
My lord,
You are appearing for?
And rather he is
for
challenging
Union of India, my lord.
Union of India. Yes. What is the submission?
My lord, this notification dated 16th May of 2025, which is has been impugned, and that notification has been it speaks for itself, my lord. This has clearly stated that all the states and UTs
have been discussed and they have been informed, and after receiving representations from different states and UTs, this policy has been implemented.
Okay, well, see, whatever the objection, let the amendment be carried out. You take all the points in the writ petition and the affidavit in opposition.
Grateful.
I am not passing any interim order.
Let us, my lord, file our because it is not.
You want to file
written
affidavit?
My lord,
My lord,
we must oppose, my lord. It must be brought it to the record, my lord. This this
there are-
amendment is absolutely.
Well, I have two small submissions, my lord. Why I'm objecting to an prayer of opposition to be filed in this, my lord, because this is causing delay. My lord, the notification of 16th May
That's why on that day I
2025, my
told
lord,
you.
let them.
See, that's why on that day I told you, you withdraw this and you
My
file.
lord, if I have to withdraw, I will have to file a fresh writ petition anyway. But my lord, this is, my lord, kindly, my lord, he's not letting me submit at all. My lord, if lordship sees my prayer, the amended prayer that I have sought for.
If the other party want to file the affidavit, how the court can stop?
My lord, let them file within a time-bound manner. And my lord, one request, my lord, I have prepared this chart to indicate why I cannot comply. And my lord, the notification of 16th May does not make it mandatory upon the workers to purchase. That is what the state government is doing. They are tweaking the notification.
Okay,
And my lord, one more difficulty, my lord. Today, I am faced with constant threats from the CDPOs who are asking me to file show causes as to why I'm not purchasing, where they are fully aware of the fact that this petition is pending.
Naturally, you have to face the consequence.
My lord, I am facing the consequences.
Once the
of
central
what,
government
lordship?
has taken the decision, it was in
My lord, central government's decision has been tweaked by the state government. Lordship, kindly seize the notification.
Central government is.
Yes, my lord. My lord, in my prayer, I have not.
The central government said
My lord, I have not prayed for and total that I have not said, my lord, the notification of 16 may be set aside. It is the central government's decision.
Correct.
What I'm saying is it does not apply to the state of West Bengal. And secondly, the central government notification.
State of West Bengal.
Yes, my lord. Kindly, no, my lord, it is not exempted. There are conditions. My lord, there are conditions in the notification which does not apply. Lord, kindly comes to my lord, page 13. Lord, kindly comes, my lord, if kindly comes to page 13 of my application, lordship, where I've annexed this notification. Lord, kindly reads with me once what they have done. My lord, it says, my lord, clause 2, my lord, it says this ministry has received representations from various states, UTs, so and so, where the field functionaries may be allowed to bring their own smartphones for the scheme work and are provided funds for purchase. My lord, these are the two conditions. And my lord, kindly sees clause 4. The implementation of BYOD be subject to the following conditions. Mandatory implementation of so and so. And my lord, these conditions cannot be met by me and it is optional upon the workers to get it. Here, the workers do not want to get it. They are making me sign a document where I have to forfeit all my rights to this phone and they may take the money back from me if there is any problem in the phone. Today, I am being prejudiced because of the steps they have taken in the notification of 17th October 2025, which is, my lord, that also I have annexed.
What is
At page 20.
Yes. What is the difficulty in the
yes, my lord. The difficulty, my lord, is this. I have handed over this chart in rupees 10,000, which they have credited to my account. I cannot purchase a phone which will meet all the specifications. Kindly let me make my submission, please. My lord, I cannot purchase the specifications that has been required under the mother notification with rupees 10,000. And my lord, the document that they have issued on 17th October, which makes me sign an undertaking that if there is any default of the specification, they will take the money back from me after I have purchased the phone. So this liability was not imposed or contemplated under the 16th May notification issued by the central government.
But
the state,
everything cannot
my
be
lord,
in one notification.
There is a simple solution to the problem.
Suppose some person has given a money to you. You purchased it.
Well, I will purchase. Let the notification of 17th October be set aside, which is issued by the state. They are holding me accountable if there is anything problematic.
Yes, so you cannot be accountable. Yeah, and the authority has given a 10,000
but my lord,
rupees.
I have done
to purchase the rupees of
I have done that research. My lord, I have done that research for within 10,000 rupees. I cannot
Where
read
is the
the
representation
specification.
that you cannot purchase with regard to this
Well, I have-
specification?
well,
Where is
these-
the representation to the authority? Show me.
Well, I have not issued a representation because these have happened during the
How
pendency
you
of the
making
writ
a
petition.
submission before this court if you have not made
And my
any
lord-
representation to the authority? Yes, 10,000
lord, I
rupees is
have
not
issued-
sufficient for purchase this specification of
My
the
lord,
mobile
these
phone.
issues have all
How the
cropped
court
up after the writ petition was filed.
Then again you file with the come with the
My lord,
amendment.
I have already come up. It is a part of this application, Lordship. I am asking
Madam,
this.
you are now raise specific question now you raise that the 10,000 rupees is not sufficient to purchase the mobile phone
Yes,
which
ma'am.
has been specified by the authority in the letter.
Yes, ma'am.
Correct.
Yes, ma'am.
So after receipt of the letter, whether you have given any representation to the state authority, so the 10,000 rupees is not sufficient for the mobile phone which the specification you has given. Where is that?
My lord, if that is the case, my lord, then I will file
You
a
have made
representation.
that because not
My
a
lord,
court.
I have brought this information to this court, my lord, after this
Every day you are
notifications.
making out a new case.
No,
I
my
am
lord, this is
dismissing it.
new case, my lord. This
Every
is
day you are
following.
making out a new
This
case.
is following.
You made out some other case in the writ petition. When the authorities come with a memorandum, now
kindly
you come
hears
with
me.
a
My lord, kindly hears
amendment.
me, my
Now
lord.
this court has put the question. Now you are making a
My
new
lord,
case.
kindly hears me, my lord. I have already pleaded this in my supplementary affidavit, which was already filed before your lordship, and they are aware of it. My lord, let them file an opposition, my lord.
The petitioner has filed an application being can 1 of 2025 praying for amendment in the writ application. Also for the respondents press for time to file affidavit in opposition in respect of can 1 of 2025. Let affidavit in opposition be filed within 10 days. Reply if any thereto. Reply if any thereto be filed within a week thereafter. Let the matter appear on 5th of February 2025 under the same heading.
My lord,
Grateful.
my lord, may I have make a submission, small submission? If it is challenged that central government policy is being a challenge itself, then I pray for my appointing ASG, learned ASG also.
Let that come. Let you file the affidavit.
Has to be served upon the office of the London.
That's why first amendment is not allowed. If it is allowed, then the notice is to be served.
My lord, my lord.
My lord, can some protection be given to the workers in the meanwhile?
Yes,
We are acting, my lord, in terms of the center's guidelines.
Next.
Wait.
Next.
19 and 20 can be taken up together, my lord. Your lordship would kindly have a look at the previous order which was passed by the Honorable Court.
Yes.
And your lordship had indicated that a list would be given to us with the relevant addresses for us to make somebody a party. My lord, they've just given us the list in court.
But I have provided the list.
They've just
Already
provided the list. We need to make them a party. I have one small prayer.
Bank of Baroda, I have taken up this issue your lordship has indicated to me. This probably relates to stress assets management branch of Bank of Baroda. If they can serve me or the stress asset management branch, I can.
We'll serve them in court. We'll serve them in court. In fact, that
We'll take to made a party.
Serve the copy. We'll serve them a copy. Only, my lord, I have one prayer. I have one prayer. My lord, if these LOCs could be kept in abeyance, your lordship remembers just a few days back, your lordship remembers I took a permission and somebody went to Thailand. Your lordship remembers that? No, my lord, I don't wish to go to Thailand. My lord, there are two brothers before your lordship.
Now change the area. Instead of Thailand, you're
That
changing
was it was a younger man. My lord. On a lighter note, two brothers are before your lordship. Two uterine brothers are before your lordship. If, my lord, one brother could travel with the other brother standing as surety for a temporary period for 5 days or 6 days, as long as your lordship, my lord, desires. My lord, if the brother does not come back, this brother, my lord, be given undertaking, can be taken into custody.
No, sir. First, you made the party. Let the notice be served. I think the writ petition could have been disposed of.
Very well, very well, very well. Because what we would ultimately pray is that, my lord, for us permission to travel abroad so that the LOCs are kept in.
How soon? By tomorrow, you can implement.
But tomorrow, we don't think we will be able to. Right. We will not be able to. My lord, so far as assistant director.
Bank of Baroda is concerned, he is repenting. Others are there.
My lord, there's ED is there and this joint director, Ministry of Corporate Affairs is also there.
Yes.
So that's New Delhi.
With regard to the two, you will appear.
Two will appear, but 1 and 3. 3 is Delhi. So
Please, Delhi.
May I seek one
You
more
do one thing,
indulgence?
by Monday, you implete this.
Very well,
and
madam.
serve the notice to the authorities.
Very well, madam.
I am fixing after 2 weeks.
But that will be too late. My lord, may I just request your lordship? We would make the amendments today. My lord makes it returnable on Tuesday. In the meantime, I would.
If the service also affected, how the Delhi person can?
No, right. I have just one prayer.
Today we are on 7th.
7th.
So you implete the party today itself, and I am
Yes.
fixing the matter on 14th.
14th is just right. 14th is just right.
Let me file the
Can I make one prayer? That is, my lord, normally Joint Ministry of Corporate Affairs is, my lord, represented by the union. That happens to be ASG's office.
Give the copy.
So we would also give a copy to the ASG's office with the leave of this honorable court.
No, my lord, the
best option would be, my lord, let them serve, my lord, Ministry of Law.
Huh?
Ministry of Law, my lord.
No, serve the copy to all and
Serve
copy to
to
the
law
SGI
and-
also. He will also take the
ASG.
My lord, ASGI does not accept, my lord, Ministry of Law.
With the leave of the court, I think I can.
Ministry of Law office is there, my lord.
In Calcutta.
Yes. 11 Stand Road. Let him serve a copy at 11 Stand Road.
So then additionally. Grateful, my lord.
The office of the FRRO has communicated the address of the Assistant Director of Directorate of Enforcement, Managing Director and CEO, Bank of Baroda, and Joint Director, Ministry of Corporate Affairs to the petitioner by a communication dated 6th of January 2026. Counsel for the petition is given liberty to add the above 3 respondents and added respondent being respondent number
4, 5, and 6.
respondent number 4, 5, 6 in course of the day.
Yes, my lord. Grateful, my lord.
All LOCs of Bank of Baroda are open to that particular authority, but there are originating officers.
But
The
that is-
originating officer is Sam Raj Kolkata.
That is not necessary.
Those details are supposed to come.
Huh?
Those
Yes.
details will come from
That
there.
the report will come.
Yes, grateful.
In course of the day. The petition is directed full stop. After impleting the above said respondents as respondent number 4, 5, 6, the petitioner shall serve the copy of the writ application along with all annexes to the added respondents by speed post.
But 2 can be answered.
Sports post, and also to serve the copy to the learned counsel appearing for the Bank of Baroda.
Grateful, my lord.
And the physical copy to the local office of the Ministry of Law Affairs.
Yes, Ministry of Law.
Ministry of
Law and Justice, 11 Stand Road.
At Calcutta.
Grateful.
At Kolkata. And to file affidavit of service on the next date fixed. List the matter on 15th
we will prefer it.
15th
we'll
January
prefer it. Grateful, my
2026
lord.
under the same.
Grateful for this indulgence. Same in the next
The
one.
communication dated 6th January 2026 be kept with the record.
Grateful.
The same order in respect of next matter.
Same also 20 also.
20.
19
and 20.
19, 20.
Both, my lord. Grateful, my lord. Grateful. Hopefully this time I should be able to.
For the 21, my lord, I am appearing for the petitioner, unwed mother. She was in six workers. So she had 3 children, 1 son, 2 daughters. Now she applied for the passport of the son given. Father's name was not required there. Now when I applied for my daughter, who's 14 years old, studying in a school, now the passport authorities are insisting for the name of the father. Lordship knows that it's impossible for me to provide the name of the father because unwed mother, Lordship, number 1. Number 2, I was in this flesh trade. Now I've started my life with my children studying there. So this is the only predicament or only difficulty where the passport authority is not issuing me the passport. They are asking me, insisting me that you have to provide the name of the father, otherwise I will not provide you the passport.
What about the birth certificate?
Yes, in birth certificate, one name has been given, one Mr. Sonu Singh. The name of the father, Lordship, I'll show you. That I have taken the instruction from my client, Lordship, in a very
Lordship. पासपोर्ट निकालो नहीं उसका बेटा का निकालो So you will also find my passport, my mother's passport. Name of the husband is not there. Then the passport of my son, which will also appear on page 13, page P2.
Yes.
Name of the father is not there. And Lordship, it has been held by several reported judgment also that in such situation, it is not mandatory to insist for the name of a father, a person who has abandoned a woman and has not even looked into the welfare of the children. Now the children, my son is 19 years old. My another, he's studying in MIT. He's doing BBA. My daughter is 14 years old, for whom I applied for passport. She is studying in the school, APJ school, Park Street. And my younger daughter, Maisha Singh, is studying in APJ, Salt Lake, 11 years. Never father, this person, Lordship knows that what happens in this trade, in this profession. Lordship, we also are not sure. She is also not sure that so many people come. Now she is living a decent life. And now she wants to apply for the admission of the daughter in a school which is named as Equal Global International School. The first condition is to provide an original passport. This is the
school. Yeah.
Dehradun. This is subsequent to filing of the writ petition, Lordship. The first, can you see the checklist? First, number one is original passport.
Correct.
And Lordship, we kindly see.
International school require the passport.
Lordship. Now, Lordship, in some of the cases, in a similar cases, there are some judgment I would like to rely upon.
I think recent judgment of the Delhi High Court.
Delhi High Court. I'm so grateful, Lordship. I'm so grateful. Lordship, this is 16 SEC online Punjab. Sir, I'm copy dijiye sir. Sir, I'll give you one copy. Sir, I'm relying on paragraph 6 to 8. This is Punjab and Haryana High Court. There is no dispute that the Lordship, may I read, Lordship? Paragraph 6 to 8.
Yes.
6 to 8, Lordship. Lordship, another I would like to rely upon is this is 2016 SEC online Delhi, Lordship.
Nigam.
Yes, Lordship. Grateful. Sir. It's a detailed judgment from 6 to 25, Lordship. It has also relied upon some of the other judgment also. So here also, my Lord has held that it is not mandatory or you cannot insist upon providing of the name of the.
Unless there is a provision in the act or the law.
Even if there is a rules, Lordship, but in peculiar circumstances where it is impossible for a woman who is an unwed mother to disclose the name of the father who has never discharged his responsibility ever regarding the upbringing of the children, then the passport authority has to see that whether the citizen of India is the first criteria, which I am fulfilling. Mother is there. And you issue passport to my brother, my son. You don't insist for that. My passport does not carry the name of my husband. And now regarding my daughter, they're asking for the name of the father. So this is, my lord, this is another judgment. And then Lordship, this one is of Karnataka, is 2022. Paragraph 12 to 14, Lordship. Sir. Lordship, this is interesting. Lordship, dear Lordship, we find in paragraph 12, in the event a single parent is the applicant without the consent of the other, the document required are proof of present address, proof of date of birth, attested photocopy of passport of both or either parent. Sir, I have a passport.
Page.
Paragraph 12.
12.
Lordship.
Yes.
In the event a single parent is the applicant, without the consent of the other, the documents required are proof of present address, proof of date of birth, attested photocopy of passport of both or either parent, and a declaration affirming the particulars furnished in the application about the minor as per Annexure G. The aforesaid are the documents required to be submitted by a single parent applicant when the other parent does not give consent. It is germane to notice that when what are Annexures C and G which are required in such a case. Annexure C is the specimen declaration by applicant's parent or guardian for issuance of passport to a minor when one parent has not given consent. So Annexure C I have to comply with. If they ask for that, I will give a declaration. But straightaway they are asking me, we will not give you the passport, we will not proceed with your application because you do not disclose the name of the father.
Where is your application? Have you disclosed?
Yes, Lordship. I will show you, Lordship.
Have you disclosed the application?
Yes. I have annexed the application which will Lordship will find on page 12 of my writ petition, Lordship. This is the application, number such and such. Given name Harshita Singh. Gender female, father's name not mentioned on the left hand side, Lordship.
Yes.
Mother's name Priyanka Singh. Priyanka is the petitioner before Lordship because my daughter is 14 years old, so I have filed this writ petition.
Petitioner.
Now, Lordship.
Who is the petitioner? Mother.
Mother. Now, Lordship.
What is the prayer?
Page 8, Lordship. Issue the passport in the name of a petitioner's daughter, namely Harshita Singh, as per her passport application reference number such and such, being passport applicant number such and such.
Where is the total passport application? You are not disclosing.
No, we have to apply online.
Online.
Then what do they? They give us a date.
Only the date.
We go there. So we went there. We have given that in our government also.
Yes. Next.
Now, subsequently, after filing a writ petition, now they have given this letter to my client saying, since you have not failed to provide the name of the father, so we are closing your file.
Closing? File.
Closing the closure of the file. This was issued on November 24, 2025.
Yes.
And this one is Supreme Court also, Lordship, 2015. Later. Lordship, the passport authority, they also follow this compendium of instruction guidelines related to issue of passport Indian abroad. उनके पास नाम कहाँ से लगे देखे Lordship 4.6 to 11. कहाँ पर ये पेज?
This is with regard to the adoption.
No, Lordship. Lordship,
4.6.
I have put a flag, Lordship. If you, Lordship, kindly pardon me, Lordship, because that pagination. I'll take that copy, Lordship. Just kindly excuse me for putting the flag, Lordship. This is the applicant for minor, Lordship. On the bottom, last paragraph, Lordship. Can I have back my that copy, Lordship? Then I can show it to you, Lordship. The relevant guidelines what they have to follow when there is the unwed mother or. I'm so sorry, Lordship, because that was. पेंशन मांगने की हो Lordship, is kindly see 4.10, 4.9, 4.10, 4.11. Single separated parent, 4.8, 4.9, 4.10.
4.8 single separated.
Lordship.
That's why you asked with regard to the annexure is there.
Annexure C is there, Lordship. That flag is there, Lordship. I'm so sorry, Lordship. I have put that flag for my.
Whether it cannot be separated. What is your case made out? It is separated or unknown?
Lordship is unknown.
Unknown.
I'm a 6 worker.
4.9 it will come.
4.9.
4.9 it will.
Lordship, correct. Unwed mother, Lordship. She was in that state, Lordship. So.
Yes. Anything further?
This is the submissive, Lordship. So I'm just saying that being an Indian citizen, why I should be deprived, Lordship.
Yes.
I want to study. I want to go to the international school. I want to have my child build up a career.
Very unfortunate case. He has submitted that his client is a sex worker and unwed mother. But he has not placed the relevant documents which was filed earlier before the passport officer. Instruction দিয়ে দাও. Now kindly first come to the instruction page 4.
There is a copy of it, sir. Please do. So I'll ask my client to provide that.
This is Harshita Singh's application for passport, annexure 1, which is the instruction. Kindly find from the bottom.
Sonu.
Family details. Father's name is mentioned, Sonu Singh. So unwed, all this. And secondly, kindly again come page 13 of the instruction.
This is Dhruv Singh.
What is
13 of the son.
Here also mentioned Sonu Singh, father's name, family details.
Passport
of the son.
Son.
Therefore, it's not the case which is being submitted.
Unknown.
Yes, it's unknown.
The passport.
If in actually your lordship is aware on the experience of taking up so many passport matters, not only in this case, but in other cases, that once the passport authorities are being troubled with grant of passport and some risk of granting passport, so many complications, because the object of the act and that, so many and that too in respect of such a case, I'm not going to again mention. And once the name of the father is mentioned, whether doctrine of issue estoppel will apply. If it applies, the judgments, whatever is there, will not apply. Because your lordship is aware, in 1976 Supreme Court down the line to Narmada Vacha's case.
Yes, once it is declared.
Once declared, and that apart, if the judgments which has been cited will not apply because there are differential facts. So he is duty bound to mention the name. Why he is not mentioning the name? Definitely there is some embargo. Instead of mentioning the name earlier mentioned, why he wants to make this application without mentioning the name of the husband? Definitely there is a purpose.
Because Lordship, there is no marriage, there is no husband. That is a fact. Now, Lordship, you see the passport of my client.
Just a minute, kindly come to, you have.
I've seen that, Lordship. I've seen that copy. Sonu Singh is mentioned there.
Not that. Kindly come to the page 21 of the document of the government.
21.
21.
That is how passport is granted. Now the conditions on which passport is granted clarified.
Got it. Priyanka Singh is the petitioner.
Lordship.
Correct. Now kindly come to the marital status
Separated. Lordship.
Then
The difficulty is, Lordship, these people are so illiterate, uneducated.
that is the problem.
That has been wrongly guided by, I am telling you very candidly, Lordship. I'm not on the point of law. My learned senior friend is absolutely correct. That since you have disclosed the name of Sonu Singh, there is no person existing in the life of person Sonu Singh. But people are coming and going. Lordship will see that the passport issued to my client, Priyanka Singh, there is the name of the husband is not there. Now, Lordship may see.
No, that's correct. Because
I'll show you one thing more.
This has been given. This has been given. Here only the question is that they have raised the objection and the document. That's why you asked where is the form. So you're online, you could not file the form. Now the authorities have brought the form.
Correct,
In the
Lordship.
form, you have mentioned the name of the father.
Lordship.
If you have mentioned the name of the father, then it is the duty of the applicant to give all the details with regard to that. If could not have been mentioned, then the judgment. That's why the judgments, if the father is not there, you not mention, so you cannot, the authority cannot insist you to mention the name. But once you have mentioned the name of the father, so it is the duty. What now? What in this circumstance? What would
Just
be
one
the-
answer. My learned senior.
I have not.
Lordship, let him complete. I'm so sorry. Let him complete.
Yeah.
Otherwise, he was so senior to me.
Yes,
My
please
client-
take it.
My
Yes,
client has clarified in the instruction under what circumstances the passport in such cases can be granted. Page 3 of the instruction kindly find. At the top. The instruction factor down. This is.
Yes, page 3.
Yes, at the top. This actually starts from the page 2.
Page 3.
So I read from page 2 bottom.
Yes.
Then page 2 bottom is this the existing policy on exclusion of father's, mother's name on minor's passport states. The names of both parents are to be varnished in passport of the minor, including cases of single parent having the custody of the child. Kindly mark it, irrespective of the status of marriage between them. In case of child of unwed parents, the names of father and mother are to be included in minor's passport. If both biological parents, accepting the parentage of the child, they are to submit their consent in the prescribed format as provided. Now, this is not applicable. Kindly come to next page, page 3. Under appendix 12, for passport to the child with their names therein, however, in case of child of unwed parents, the name of the father mother is not to be mentioned in minor's passport unless the foregoing requirements are fulfilled. The requirements are A, when the mother is an Indian citizen and claims that the biological father has no contact with the mother or the child after the conception, birth of the child. Is not the case made out. Father's name is mentioned. B, where the child's father is unknown, for example, a child born after rape, etc., is not applicable. Name is very much known. It has been mentioned in the passport application. 3C, where the biological father has terminated the relationship with the mother, is not also there. Neither custody, judicial custody, nor compliance or fulfillment of these requirements. So how can we grant passport? We are bound by the rules, regulations.
Now, so I've taken the section. She's in the court. She's saying whatever she's saying. First of all, she's saying that these are because we are so uneducated. These are brokers. They insist.
You completed.
Yes. No,
These
I
are-
am submitting last. Let them mention the name of the father. We shall grant passport.
Lordship, there is no father. That is his candidacy. She want to file an Annexure C also, Annexure G also. She will make a declaration that subsequently, what is the insecurity? Suppose if I apply for a passport and I don't mention the name of the father, or I suppress it, or I say I'm unwed mother. Now somebody after few months or a few years crop up and claims that I am the father, my name has been deliberately suppressed by my wife, and I am the father of the child, then there will be a proceeding against the mother. So in order to safeguard that, in their guidelines, they have provided an affidavit. They say that you file an affidavit and you declare that you have been disowned. In that situation, will you provide you the passport subject to if there is somebody comes and you will be charged for that suppression or making such false assertion. So, my lord, this is the first point. Second point is she's saying that in this situation, what happens? We people go to a broker or any agent, and they say that because they are also not so legal expert, they don't know the guidelines. You know, you have to give the name, you mention the name, otherwise that not be considered. In fact, she's saying when she went to the interview, there also the officer said that without the name of the Sonu Singh will not be able to further proceed with your authorities. But the fact remains is that there is no such husband of her. She is an unwed mother. She was.
There is a requirement in the plain.
That is the difficult. This was not. This is just now I've come to know, Lordship. I'll find one supplementary to that, Lordship. Kindly see the predicament of this lady. They are not so educated and so well aware of the.
Not made out that case also.
Yes, Lordship. That has been missed, Lordship. That
How
is.
the new case can be made?
Lordship, I'll withdraw this application, Lordship. I'll come back with the liberty revolver. Because only difficult is there's the urgency because she has to take admission of children.
Correct. The court is also worried
Yes,
about
yes, yes.
but the court has
No, I'll do it. I'll file it day after tomorrow, Lordship, with all the necessary documents and all the averments that what happened there exactly.
at the landed council for the parties. After hearing
Husband Nibena.
the landed council for the petitioner find that there are some technical defects in the writ application which cannot be cured.
I'll take the liberty here.
Implementing
My lord, sorry, I've just have a talk with my senior. He's saying that you withdraw that application, a passport application.
Correct.
You file a fresh application with all those, and then we'll consider. Lord, if that liberty is granted, Lordship, then I will not go for the unnecessary.
Way of supplementary affidavit or by way of amendment. Accordingly, counsel for the petitioner prays for withdrawal of the writ application with the liberty to file afresh. Accordingly, WPA number so dismissed as withdrawn. How withdrawn with the liberty to file afresh, if any. It is made clear that in the meantime, the petitioner made a fresh application after withdrawing the previous application before the passport authority shall take appropriate steps in accordance.
I'm grateful, Lordship. Much obliged. Grateful. Much obliged, Lordship. So difficult, Lordship. Grateful.
My lord, item number 22. I am appearing on behalf of the petitioner. This petitioner is 84 years of age. Her son, he is in the custody for the last 23 years. Since 2nd of January 2023, my lord, multiple applications seeking premature release. Initially, he made multiple applications. Thereafter, my lord, on 14th of September 2022, the State Sentence Review Board had rejected his plea. Subsequently, my lord, the State Sentence Review Board had similarly rejected premature release of another person. His name is Piyush Goswami in connection with one W.
How many years he is in custody?
23 years.
What is the total punishment? Life.
Life.
302.
Yes, my lord. But my lord, my humble prayer will
life,
be
at the time of sentence, it is there. It is total life.
My lord, that was not mentioned whether during the remainder of life or not. Because my lord, 23 years back, my lord, life means life. But my lord, see till date, my lord.
Life, but now it has been segregated.
Yes, judicial. Yes, my lord. That's why I have come before your lordships. But in the same case, one of the accused persons has already released, my lord. My lord, initially
whether your case has been considered by the committee.
Yes,
commission.
State Sentence Review Board considered and rejected.
Where is the rejection?
My lord, page 96. Page 96. Yes, page 96. My lord, I am reading. This is an informative prayer for release rejected, has been rejected. But my lord, similarly rejected case, another accused person of the same case, his prayer, when he filed a writ application, during the pendency of the writ application, his prayer was allowed by the State Sentence Review Board.
Where is
that? That is, my lord, page 97. Yes, initially rejection was set aside by this honorable court. My lord, page 97. January 17, 2024. Page 97. The Honorable High Court set aside the order of rejection because that was not followed the regulation, that was not followed the parameters. Thereafter, my lord, that was set aside. Subsequently, he was released on 10th of July 2025.
Yes.
My lord, he is, my lord, similarly situated person, my lord. Yeah, my lord, if your lordship sees page 102 to 115, my lord, his conduct inside the correctional home was good. Page 102 first, my lord, kindly comes.
Yes, what is the instruction?
My lord, I have no instruction, but my lord, 96, page 96, my lord. Can you see the wife of the last line? The wife of the victim has strong objection on the proposal of the premature release. Kolkata police authorities raised strong objection against release. Considering the above fact and circumstances, premature release is not recommended.
What was this? What was the offense against him?
Offense 354, my lord, 302 and 302, 34 and 354 and.
What about the 30? How many persons were convicted along with this petition?
Convicted 2 persons.
No.
2 persons.
No. More than 3 persons. More than 3 persons.
What about the other persons?
1 person already released.
Yes, my lord. 1 person already released. And
another person is also before your lordships, item number 23. 22 and 23, both are before your lordships. My lord.
Under this time, 3 months time is required.
3 months?
So instruction.
You do one thing. Tomorrow is another meeting is there. The review committee meeting is there. I am also the board on that. So let the matter. I am fixing on next week.
My lord. My lord, before that, my lord, only one humble prayer, my lord. If your lordship sees character certificate page 116, my lord, he is an excellent performer inside the correctional home, my lord. My lord, kindly sees page 116. He is an open air correctional home. For the almost last 5 years, he have never misused that liberty, my lord. Your lordship knows the open air correctional homes. They can go out of the correctional home. They work there and they come back. They have never.
Not so. These convicts are working as a cook in the jail inmates for cooking food and supplying the.
He is working in hospital, my lord. Jail hospital.
Correct. That's what I'm telling. That's what I'm telling.
Page 102 to 115.
Persons have been engaged for different works. If he is a cook, he has been given the cook work. If it is a carpenter, whatever the work has been assigned, they have to work.
And my lord, the person who was already released, Piyush Goswami, he was the captain of the correctional home football team, my lord.
Okay.
He went outside the correctional home also.
Let it come on 21st of January.
My lord, kindly comes to page 116 first. This is the certificate, my lord. Character certificate.
Correct. So I have gone through. Let me come on. Let me see.
At 2 p.m.
Not come on 21st.
21st. 21st, my lord.
What is the other matter?
Same, my lord. Same matter.
Which matter?
Item 23.
22 and 23.
Yes, my lord.
22 and 23. Yeah. Let both the matter be placed on 21st of January 2026 under the same heading.
My lord, may I humbly pray for one thing? In the meantime, if any, my lord, state sentence review board meeting is.
In the meantime,
yes.
The state. What is the committee name?
State Sentence Review Board.
State Sentence Review Board are intending to consider the case of the petitioners. The authorities are free to consider.
Grateful, my
lord. Petitioner for granting remission.
Grateful, my
free granting remission to the petitioner during the pendency of the.
Grateful. I'm so grateful, my lord. Well, shall I file the affidavit of service in both these two matters? এটা
Malad,
22, এটা 23.
Malad, item number 30,
22 এটা,
39
এটা
and 40,
23.
Malad.
20,
Malad,
22, 23.
Malad,
Grateful, my lord, so grateful.
the entire vehicles are stuck up in the road, Malad.
It will, yeah, it will taken tomorrow. It will take.
Tomorrow has to be mentioned, Malad.
No, tomorrow I will take the matter.
Malad, instead of tomorrow, day after tomorrow, Malad.
Day after tomorrow.
Yes,
Day after tomorrow, 100%. Item number
38, 39 and 40, Malad.
38, 39, 14.
I serve notice upon the opposite parties again.
Day after tomorrow.
Day after tomorrow.
Eh,
As if
38,
38, 39 and 40.
38, 39, 40 be listed on day after tomorrow is 9th.
Yes, Malad, 9.
9th, na? On 9th as urgent motion at the top.
Get
Sir, I shall travel your lordship only 1 minute time, my lord. Item number 27, only for consideration of my representation.
Huh?
Only for consideration of my.
What representation? Who is for the other side? Instead, come tomorrow, I will take the matter. It will come serially, tomorrow it will be taken.
Today we are in the matter.
Today, I don't know whether if the 2 PM matter will not be taken, it will be taken. वो 3 ना? तीनों को top में रख। 9 तारीख, हाँ, चलिए। Item number?
My lord, in this matter,
Yes.
my lord, I as a statutory authority, it's a Bureau of Energy Efficiency. If Lordship knows that in all, if I can say for in a simple way, even for a AC there are star ratings. Now, my lord, every country there are some mechanisms to see that energy is conserved. And my lord, there are promises made by the Prime Minister also, so that in India also we take into account certain mechanisms so that energy is conserved in variety of ways. For that reason, my lord, this bureau has been entrusted with lot more power to monitor and take variety of steps. Now, this matter, my lord, will have a far-reaching, my lord, consequences all over pan-India. But this BEE, that's me, who is the authority, is not made as one of the parties. So I made an application for admission of party. They are enjoying an interim order. Today, I don't want to say that frustrated. Kindly add me as a party because I have a lot of things to say. Because fundamentally, my lord, it's fossil fuel, that electricity that we get, my lord, mostly that comes from coal. But there is an effort that to switch, not entirety, from hydro, from sun, from other renewable sources. So variety of regulations in different authorities are there. Now, there are two legislations in the field. One is the Electricity Act, and under that the regulator is the West Bengal regulator, which is within the state. Now, there is another act, this, my lord, the Energy Efficiency Act, under which me as a statutory body initially had a less power and less monitoring, less steps. But from 23 onwards, there has been an amendment in the act by which I have to monitor, I have to see variety of things. I made an application. So I don't think learned Advocate General would be objecting to my being made as one of the respondents, so that Lordships can, because whatever ultimately decided by your Lordships, my lord, in other states, pan India, this will be referred also.
Okay.
So today, my lord, if Lordship kindly allow me, that can one and keep the matter on any day, and in the meantime, I can use an affidavit in opposition. Can two.
But I do not know what this entity is.
No?
And how are they interested in this litigation?
I can demonstrate that here and now.
On the application?
No. This application has not yet been served.
No, it was what you are saying. You have not served it. I'm so sorry. Why have you not served it? You held a 2 hours conference and not served this. But I'm so sorry. So sorry.
So you are Mr.
But I
So you are
a
referring to
petition.
petitioner.
Hear me, Lord.
I am the sufferer union of India suffering an interim order.
It's
Okay, you saw the copy?
Yes, well, this
You
is
saw the copy to both
Let a copy.
petitioner as well as the respondent.
I can just show two sections why I am so important in the decision-making process. Straightway.
He has to show that he is a necessary.
Correct. Exactly. That's what I'm saying.
He may be the author of everything.
No.
But I may not have anything to do with
it. Correct. Completely true. Lordships, kindly straightway come to.
Anyway, in that case, maybe come back on the next day because I do not know what this
entity
is.
I am saying this is in the act itself. May I just show sections, nothing to do with the fact. Kindly take the act.
Which act?
Well, I am giving the copy. This is the 2000.
Private matter.
This is. Kindly do not see this.
Have any grievance against this body? That's Bureau of Energy Efficiency.
No, but I am to monitor after the
As per his
amendment.
contention, this is the authority now is dealing with all the.
Not only dealing with, but also to ensure that you do not continue with the coal. You have to switch to some sun, some to hydro, and some to renewable. And
so he has a power of the sun and all.
Yes. So that the sun spreads in every states. But because once the nation takes a decisions, my lord, in other foreign countries, that we will certain percentages which switch from the coal to some others. Then my lord, all over the nations. It can't be that in Kerala will be going one way.
Due to the environment and all.
May I just for the satisfaction of your lordships? Lordship has,
I think, Milord, may I say this? Milord?
yes.
Piecemeal this argument in between, that is what DPMs. There will not throw light on the subject.
No, it is a serious case.
No, very, very serious.
Yes.
Whether for at all somebody who should be heard for adjudication of this matter is to be told or demonstrated before the court. But may I tell you, Lordship, one thing, Milord? The respondents who are already on record, Milord, they have taken a point that the writ petition has become infractive. Why? Because my parent challenge is to a notification of 20th of October 2023.
20 October 23.
Well, that notification, they have said in an affidavit in opposition to the CAM that notification which is under challenge has been superseded by a subsequent
Another note.
Correct.
of
September 25. There my power has come even more. That's what I'm saying.
Therefore,
That's why I have come now.
personally feel that Milord, the writ petition is to be amended. Thereafter, if my learned friend clients want to, Milord, get themselves agreed. Of course, Milord,
Have you have filed an application for amendment?
yes,
Can
I come back, file an application? My only problem is that the interim order is to expire by 9th. Please extend it for some time, maybe a month or so.
My lord, I have.
Or 2 weeks. We'll come back by 1 week.
How soon you will file affidavit?
My lord.
You will file affidavit to this can one.
What I'll do is, Milord, kindly permit me to file an affidavit to this, say within 2 weeks. Within 2 weeks, Milord, I'll file my amendment application also. Your lordship takes both up on the return.
Madam, may I just discharge?
Mr. Just, what is your contention?
My lord, I am the worst sufferer. Now, my lord, my learned senior friend is saying that he is suffering, so he has become an intervener. My learned senior friend wants to amend the writ petition. Now, this writ petition was filed in 2024. They did not press for an interim order. Now, my lord, when affidavits were exchanged, everything was on record. The matter was ready for hearing. One fine morning, what happens is matter was argued by my learned senior friend. I got stuck. I was on my legs, my lord. And that point of time, on 18th, just before the vacation, on 25/9, my lord will kindly see an interim order was passed. That was after 1 year after filing of this writ petition. Now, my lord, after that, all these problems have started. Intervener has come. They are wanting to amend. Now, my lord, we are suffering this interim order. Okay. So, my lord, at this stage, my lord, my prayer is, my lord, that I cannot shut the doors for any of my learned friends for taking out application. But, my lord, some priority, because it will be heard. Affidavits, everything.
I have only two things to say. I completely agree on the point that it needs to be heard expeditiously on a particular completely. But in the correct, but in the same tune, I also say, Lordships may today itself allow me to add as one of the parties so that in the meantime I can utilize for my oppositions. Why I'm saying, if Lordship feels that my submissions is not reasonable, kindly reject it, because it may not be. There are cases where Lordship has to look into very depth of it, whether I'm a necessary party or not. If I'm able to show what is the challenge and what is my role post amendment, and if Lordship feels that I am a necessary party, then, my lord, following series of judgment, including I have also read one of Lordship's judgments also, that are you connected anyway? Lordship's language used in a party, necessary party or not, in one of the judgments very recently. The principle laid down by your Lordships was, are you no way connected? If so, no. Are you connected? Yes. May I just show it's not my submission. The act itself made me that not only I'm connected, I am an authority without whose consultations even none of the notifications can be made. And I am the authority who has to ensure the compliance. And I am the authority who says how much percentage of variety of fossil fuel or other fuels have to be, my lord, utilized or not utilized. For that purpose, if Lordships kindly straightway see.
But Milord, he doesn't have any relation with my client.
No, I have. I'm showing I have.
Of my status, that is the electricity distribution company.
No. But this is completely.
Okay. In that case, what I propose to do, you also wanted to file the amendment, correct? And you want to file affidavit in opposition. So let you file. How soon you will file affidavit in opposition?
The affidavit
of the CAN one.
addition, give me 2 weeks time.
2 weeks time. And your amendment application?
Within that 2 weeks.
Two. So you do one thing, you file two affidavit in opposition application within 2 weeks after serving the copy, and
My lord will record my vehement objection, my lord, because what is happening, my lord will kind
and I am fixing the
Because my lord, I have the
after 2 weeks. After 2 weeks, only with regard to hearing of the CAN application.
Yes.
Correct.
If such time, please extend it.
If time is extended, I will observe.
My lord will kindly observe, because what is happening, my lord, my submission before my lord will kindly record that for my benefit, my lord. That, my lord, this writ petition was filed in 2024, my lord. They obtained an order on 25/9/2025, and then now, after obtaining the interim order, they are wanting to amend, prolonging the entire litigation where affidavits and everything has already been exchanged and it is ready for hearing. So, my lord, it is.
Could have appealed against that order. My learned friend.
No, he is not telling that even only his submission is to be.
There are very
If, my lord, if I don't oppose.
Very well.
that is the fairest.
The applicant, namely
Bureau of Energy
Bureau
Efficiency.
of- Bureau of Energy Efficiency has filed the present application being CAN 1, CAN 2 of 2026, praying for addition of party as party respondent in the present application on the ground that he is the necessary party for the proper adjudication of the instant writ application. Learned counsel appearing for the petitioner prays for time to file affidavit in opposition. Learned counsel for the petitioner further submit that the petitioner has filed the present writ application challenging the notification dated 20th October 2023. Now, subsequent to filing of the present writ application, the authorities have superseded the notification dated 20th October 2023 by way of another notification dated
27 September 25.
27 September 2025. And according the petitioner prays for taking appropriate step for amendment in the writ application. Counsel for the petitioner further submitted the petition is enjoying the interim order which is till today and prayed for extension of interim order till 9th January, and prayed for
Interim order is still
9th January. And he prays for extension of interim. And at counsel appearing for the respondents raised objection for extension.
Well, I am appearing for only respondent number 1. I don't know one minute, because I don't know who is appearing for West Bengal.
Interim order on the ground that the petitioner has initially filed the writ application in the year 2024. Till the month of September 2025, the petitioner has not prayed for any interim order. The affidavit has already been exchanged, but all of a sudden, just before the vacation, the petitioner has got the interim order, due to which the respondent number 1 is suffering very badly, and he submit that interim order cannot be extended. Had the learned counsel for the respective parties, the petitioner is granted liberty to file affidavit in opposition in connection with 2 of 2026 within 2 weeks from date. In the meantime, the petitioner intend to take appropriate step for amendment of the application. The same can be taken within 2 weeks from date. As this court find that the petition is already enjoying the interim order, and at this stage it is not proper for this court not to extend the interim order. Accordingly, for the interest of justice, the interim order is extended till 29th of January 2026, or until further order whichever is earlier. Let the matter appear on 29th January 2026 under the heading urgent motion as within item number 10.
I'm grateful.
There's only one, so far as CAN 1 is concerned, Mayor.
Two.
No, there's a CAN 1 on which, Mayor, I've got the.
Obtain an order.
The CAN 1.
CAN 1 was filed by the.
For an interim order. For the
May I file my reply? Affidavit in reply to CAN 1.
You are filing?
Yes.
The reply filed by the petitioner, in respect of the can one, be kept with the record.
I'm grateful. I'm grateful, Lordship.
Well, I shall use reply in the meantime because Lordship has indicated.
In the meantime, the petitioner also liberty. In the meantime,
The applicant.
in the meantime, the applicant is also applicant of can number 2 of 2026 is liberty to use the reply to the affidavit in opposition, if any, filed by the petitioner.
My Lordship.
Thank you.
Well, my lord, before my lord takes up at the cost of my lord, with the leave of my senior my lord, on Monday a leave was sought, my lord, before your lordship regarding the bar council elections, my lord. Leave was granted, my lord. Today the matter is fixed as item number 58, my lord. My lord, service is complete, my lord. My lord, the nomination process and my lord, the preparation of voters list is in progress, my lord. And my lord, I have prayed for interim release, my lord. I have prayed for immediate seizure of the office.
Immediate seizure of
my lord, of bar council. There, my lord, there are certain prayers, my lord, kindly takes us.
You will remain in bar if the office is seized.
My lord, there are materials to that effect, my lord. I shall substantiate, my lord. Kindly takes up, fixes the time. I shall serve a notice, my lord. It's expeditious.
When?
My lord, today, my lord. My lord, my lord. My lord.
Today
at 3:30, my lord. My
3:30.
3:30
bar resolution.
3 o'clock, my lord. I shall, my lord.
And 3:30 bar resolution, taking the order against the bar council.
My lord,
then it is very dangerous to you.
Takes it up at 3, my lord. It's, my lord, compelling.
Come
My
tomorrow.
lord, compelling circumstances. That's why, my lord, I wouldn't
What is the urgency?
My lord, the urgency is that this schedule for the election was published informally.
When?
My lord, informally 5th December.
Correct.
5th December. Thereafter, my lord, the preparation of voter list was ongoing. Now, this entire voter list is not accessible by its members on its website. The voter list has been forwarded to different bar councils across West Bengal, my lord. Now, my lord, this is the preliminary list. Then, my lord, certain members of the bar council, through the social media, they published a form, not official notice, my lord. Now, this form indicated that names of the members which are missing from the preliminary list are requested to submit this form, and then names will be added, my lord.
By 6 January.
By 6 January, my lord, which is, my lord, which was yesterday, my lord. Now, my lord, our apprehension is, and my lord, we have made complaints, my lord, that
what is the urgency today?
My lord, today is, my lord, this is ongoing process. There is a consultations. There is a committee.
Tomorrow within 5 matters. As urgent motion.
My lord, top, my lord, that the fairly at
within 5 matters. I can say.
So obliged, my lord.
or my about the cost status.
Kindly do not take me amiss, my lord. I'm so grateful. I'm so grateful, my lord.
58.
58, my lord.
58 ना कल के देखो 5 मिनट के अंदर कर दे हाँ अर्जेंट ना अर्जेंट मोशन 5 मिनट टॉप 5 में कर देना yes
especially this matter.
May it please your lordship, I beg to appear on behalf of the petitioner, but we are using an exception to the report, my lord, which was filed by the Election Commission of India. But in essence, my lord, we are adapting the report. It bolsters, my lord, the allegations which were leveled in the writ petition. Only with the, my lord, the only exception is, my lord, para 3. All but para 3, my lord, we are accepting, my lord.
Para 3.
Yes, para 3 of the report.
Para 3 of the report.
Yes, my lord.
Where is the report?
My lord, we'll find it at page 2 of the report.
Yes.
My case is that we were coerced to do this by the superiors, regarding which, my lord, there were also departmental proceedings, my lord, which were proposed, and proceedings are on, my lord, at the behest of, my lord, the proposal of the ECI. So, only save and accept this. We are disputing this para. My lord can accept the report, my lord, and dispose it of, because now, my lord, the SIR is also in progress. This writ petition was filed at a period of time, my lord, when SIR was not in vogue. Now, my lord knows, my lord, SIR is in progress now. My lord, the hearing is also on, and my lord, everything is now coming to light. In fact, my lord, regarding that matter, the ECI has now come up with, my lord, the matter which I moved, my lord, just prior to the vacations, my lord. They have, my lord, accepted the contention, and they have now come up with a corrigendum that the OBC certificates, yes, they will not be accepting that. So, my lord, can dispose it of, my lord, recording, my lord, only this fact that we are also accepting the report.
What was the prayer in the writ petition?
In the writ petition, my lord, we had prayed for, my lord, inquiry by the ECI, page 16, my lord. Direct a probe into the illegalities of manipulation of electoral rolls in the state of West Bengal in various assembly constituencies by including foreign citizens in electoral rolls and immediately reverse such illegality by taking appropriate measures. So that is already on, my lord. And my lord can also record, my lord, that since, my lord, I am a victim who acted under the dictation of the superiors, my lord, I have also said, my lord, I have submitted this also, my lord, previously. If my inputs are further required, my lord, I am always ready and willing, my lord, to give such inputs to, my lord, the ECI. Because the prayer for CBI goes because SIR is now being undertaken by the ECI itself.
Yes.
But I don't have any problems with that. Not that's the writ petition has probably outlived its utility. Number one. Number two, insofar as the other aspect of the matter is concerned, not so far as the that may have an impact on the disciplinary proceedings. So Lordship will kindly not record that.
No, my lord can record, and my lord can record that my lord is not entering into that.
Yes. The petitioner has filed exception to the report filed by the respondent number 1 and 2. From the report, it is found from the exception, it is found that the petitioner has accepted the report filed by the respondent number 2, except the amendments made in paragraph 3.
Wait,
3. This court find that the main grievance of the petitioner and the prayer in the
16, my lord.
Prayer of the writ petition in the present writ application for direction upon the Election Commission of India for conducting inquiry into illegalities and illegalities and manipulation of the electoral rolls in the state of West Bengal. Not the the respondent number 1 and 2 has filed the report which has been duly accepted by the petitioner except the amendment made in paragraph 3. Thus, this court did not find any further remains in the present writ application. Accordingly, writ application is disposed of.
Extremely grateful, my lord. And the other matter, my lord,
exception filed by the petitioner be kept with the record.
Extremely grateful, my lord. The other matter, my lord, has already, my lord, disposed it of, my lord, by allowing the anticipatory bail, my lord. So, but I understand that he's appearing because, my lord, there was an order in the assignment order that both will be appearing together. Grateful to your lordship. With your lordship's leave.
Thank you. कौन सा? 20 फॉरवर्ड होके नहीं है मतलब? कल ऑर्डर हुआ था कौन सा? फाइन चैम्बर से लाए नहीं इन लोग, वो ले लीजिए फाइन। क्या और तो कोई फाइल नहीं है चैम्बर में, कोई फाइल नहीं है, 2 ही फाइल तो था चैम्बर में। 24 देखो मेरे पास नहीं है, कल ऑर्डर हुआ, कल का क्या ऑर्डर है? मेरे पास नहीं है। ठीक है, दूसरा कॉल करो, अगर वो फाइल नहीं है दूसरा कॉल।
25, my lord, I beg to appear for the petitioner. My lord, I would candid before your lordship first one thing, my lord.
my case is relates to an atrocity upon a senior citizen. My lord, in the writ petition, though my lord SDO has supposed to be a party in the proceeding, but my lord, I made a police personnel as a party proceeding because basically, my lord, I don't have any direct grievances against the police. Otherwise,
What you prayed for? What is your
I
prayer?
prayed for protection of the senior citizen in view of the, my lord, Senior Citizen Act, because the daughter-in-law and son, the respondent number 6 and 7, all son and daughter-in-law was torturing me, and after filing writ petition, my lord, 2 son left the home. I don't have any, my lord, direct grievances against them, but so far as, my lord, 6 and 7 are still my lord, torturing on me.
Who is 6?
6 is the, my lord, middle son, and the 7 is his wife. These two.
Son and his wife.
Son and his wife. Now, my lord, property is me. It's not that I inherited from my husband.
Your mother.
I am the mother.
Hmm.
And my lord, I lodged a police complaint in the year 2023.
Hmm.
And my lord, I filed a suit. My lord, the suit order is there. My lord, page 35 is the police case 91 received by me.
Hmm.
Because my lord, kindly see the page 35 in my writ petition.
Hmm.
Is Mohestala PS case number so and so I lodged. Senior Citizen Act was incorporated, my lord.
Page 30?
Page 35.
35.
The 91 note.
Page 35 is that notice. And
Yes, my lord, kindly see the issued to whom the petitioner before your lordship. 91 is
page
the
35 is notice under
91 given to the complainant pursuant to my complaint.
Right.
My lord, 2 is the petitioner before your lordship is Ranu Karmokar.
Hmm.
And my lord, the section is PS case is there in the reference and the sections as well. Yes. Now, my lord, thereafter, what has happened? I lodged several GTs. Now, thereafter, I approached the suit court as well, my lord. I obtained an injunction, including, my lord, the civil court thought it fit to, my lord, not to dispossess anyone. Page 62.
Page 62.
Page 62. Maintaining status quo is there. But still, my lord, I got torture from my son and daughter-in-law.
So why you're not filing an application 151 before the
My lord, subsequently the suit was withdrawn on the pretext that the matter got, my lord, they would not torture me. I, my lord, withdraw it after filing writ petition.
So suit there is no suit now.
There is suit.
So what is the prayer now?
My lord, subsequently again I was tortured, I lost it. My lord, I want, my lord, kindly
But this court is not having
my lord,
determination.
in a Senior Citizen Act.
Senior citizen, but you are asking the relief against the police.
My lord,
Direction against the police.
protection, my lord, without police, my lord, may I go there, my lord, that way?
If protection, if you going under the act, then the SDO and the DM. Authority and the appellate
My lord, may I
authority.
incorporate SDO and come back, my lord?
And you have not made a complaint to the SDO.
My lord, that I did, my lord.
Then
I lodged a complaint, my lord, to the.
you do one thing, you withdraw this petition, file a complaint before the authority. If not, they are not taking come, then
Lord, kindly give me liberty, my lord. Otherwise, my lord, because my lord, I don't.
Fees of the advice.
My lord,
You'll pay the fees of the advice.
my lord, we are, my lord. It's a learning session, my lord, for me, my lord. Because I don't have any direct grievances against.
For the petitioner prays for withdrawal of the presented application. Accordingly, WPA number 26739 of 2025 is dismissed as withdrawn. However, the dismissal of the writ petition will not prevent the petitioner to make appropriate application, appropriate complaint before the appropriate authority for her grievances. And if any application is filed by the petitioner to the appropriate authority shall take appropriate steps in accordance with law.
Grateful. Great. Great.
Plus 26, I am for the petitioner, my lord. In this matter, my lord, I am being led by Mr. Shuddha Banerjee. He is not.
Where is he?
My lord, he is not in the court today, my lord.
Huh?
My lord, he is not in the court today, my lord.
He was here.
My lord, he in second half, my lord, he is not there, my lord.
Second, he went to the
My lord.
ROC.
No, my lord. That is, my lord. If your lordship, my lord, kindly fix it tomorrow, my lord.
What is the matter?
My lord, this is relating to my lord's a bid. My lord, I am the highest bidder.
Not today.
Bidder, my lord.
Next.
Great.
Lord, I am for the petition on this case.
Yes.
There is my affidavit of service, my lord.
Yes.
My
What
lord,
is the prayer?
my lord, prayer for transfer of license from Taratala to.
Temporary Muslim marriage registrar.
Yes, my lord.
From Taratalla police station to
Metia Buruj police station.
Metiaburg police station.
My lord,
You
what
made an
is?
application.
Yes, my lord,
Where is
page
that
13,
application?
page 13, my lord.
Huh?
At first, my lord, kindly see page 11, the provisions of law.
Hmm.
That the last paragraph, my lord.
Hmm.
Transfer, suspension, it will, my lord.
Question of suspension, dismissal of removal of so shall be dealt by the district registrar and the inspector general of registration, who shall submit the proposal to the government. Yes. So you are.
So, my lord, I made
you are
an.
having the certificate. You are having the order of the marriage certificate, marriage officer.
Register, my lord. Yes, my lord.
Who are you?
I am the registrar of Taratala police station. My lord, kindly come to page 10, my lord.
Registrar.
Yes, my lord. Come to page 10, my lord.
Yes. In compliance of census and so. What is your name?
Zakir Hossain Mondol. First paragraph, my lord. My license was issued by the government, my lord.
Let me understand. Zakir Hussain Mondol. Zakir Hussain Mondol, son of Wali Hazad. Alihad Mandal. What is your name? What is your father's name?
Wali Had Mondol.
Can you see the order? Turn page 11. Alihad Mandal, not Walihad. Kindly see the page number 9. Line number 3. Your name, son of?
Zakir Hossain Mondol, Wali Abad Mondol.
Where is Wali? Ali. Alihad. A-L-I-H-A-D. And your is Wali. W-A-L-I. Which is correct?
My lord, according to government order, my lord, Walia Had.
Appointed as a temporary MMR.
Yes, my lord.
What is MMR?
MMR, Muslim Marriage
Registrar.
Registrar, my lord.
In excess of so authorizing to register Muhammad Muslims within the jurisdiction of Tartalla PS area.
Yes, my lord. I am praying for
the appointment of any permanent MMR for the set PS or license is revoked. So 2014.
Yes, my lord.
2014 you have been appointed.
Yes.
So till that you are continuing.
Yes.
Now new MMR is appointed.
No, my lord.
Sure.
Sure, my lord. I am.
And you are the only the temporary.
Temporary, my lord.
Temporary. And
Yes.
this order has not been revoked. There is no time
No,
limit.
no, my lord. My lord, kindly.
So where is their application? What is the page number 10?
What is
the
the
license?
License, my lord. My application is page 12, my lord.
Already been appointed as census, we have from the assuming charges census and so.
My lord, kindly have a look to page 13, my lord. A coordinate bench of this honorable court was pleased to pass an order of transfer, and that was implemented by the
Page 13.
Page 13.
Ah.
That order was complied with and implemented by the government, and
Where
the
is representation?
page 12, my lord.
I cannot understand page 12. What is written here? Yes, what is your instruction?
Sir, Lordship, I have not received the instruction yet because of
Taking the brief, coming before the court without the instruction or appearing for the state.
Lordship, we have already
What is going on?
informed that we have already informed regarding the information because the
So whether this is pending, I am disposing of.
disposing of now.
License is not revoked. You still working.
That is what we have asked for to know because it is a
Correct. Whether it is revoked or another person appointed in the Tartalla PS station or not.
That is what we have asked.
When you will bring the report?
Lordship, 2 weeks. 2 weeks.
2 weeks.
We have already.
Tartalla is here. Your office is there.
1 week, Lordship.
Counsel for the respondent prays for a week time to bring on record whether the the order dated 22nd July 2014 and the license issued in favor of the petitioner on 25th of September 2014 and the representation filed by the petitioner on what is the date of your representation? 17th October 2025 is still
17th October
still in
2020.
existence or not. Let the report be filed within a week. List the matter after serving the copy to the land council for the petitioner. List the matter on 20th January 2026 under the same heading. Affidavit of service recording. We kept it there.
No, it will appear at the top, my lord.
Yes,
My lord, item number 24 has not called on. My
the file is not here.
lord. Today it will be called on or not? 24.
24 tomorrow.
24, my lord.
एक काम करो मेरा
20
से पूछो फाइल है कि नहीं ये let me assert. The already entry mode is extended yesterday.
February. But in that case, your lordship, take it up on some other day.
Okay.
No difficulty.
Okay, I will not take the matter. If the file will come till when the matter
9th of February. February.
February.
End of February. 6th of February.
6th of February.
6th of February.
6th of February.
At the top, 20.
Okay, if the file will come, then we'll see. I will not call the matter.
Wait.
If it is not called, tomorrow it will be said, you mentioned.
Wait.
Today I will not take the matter.
Wait.
I can sure
I
that.
am here, my lord. I am here.
Okay.
No, call for it. Suppose the date comes.
नहीं,
Wait.
it is urgent motion, not top. Urgent motion will be taken. Yes, call the.
28, I'm appealing for the respondent.
Yes.
I appear for the petitioner, my lord. I appear, my lord, I'm being led by Mr. Jishnu Chaudhary, my lord. If your lordship may kindly fix it, my lord, on Friday, my lord, if it's possible, my lord.
The petition challenging my order declaring his clients as
Fraud.
a welfare defaulter.
Fraud.
I want to file a short report, my lord, in form of affidavit. Give me 7 days time. I'll come back and they even want the same today. They want the matter to be fixed on any other day.
My lord, we are pressing for certain interim orders, my lord. We are pressing for.
Interim order as on the date, my lord.
What interim order you prayed for?
My lord will only kindly look at the prayers, my lord. Lord, I've been classified.
Problem. All persons are mentioning the matter in the morning. And when the matter is listed, you are taking
There is
time.
no scope of interim order, my lord. And even
My lord.
if it is there, my lord, I will, my lord, beseech your lordship to grant me 7 days time to file a report, my lord, in form of affidavit. Then the matter will be before your lordship
My
for
lord,
adjudication.
my lord, in that case, my lord, if I may pray, the matter can be kept on the 21st, my lord, because my lord.
21st. Okay, no problem. 21st.
21st.
21st. Counsel for the 21st.
21st, my lord.
As per the prayer made by the counsel for the petitioner, let the matter appear on 21st of January 2026 under the heading urgent motion. In the meantime, the respondent is directed to file the report in by way of an affidavit after serving the copy to the land counsel for the petitioner.
However, my lord, I shall indicate this, my lord. The reports that are filed by the department on the earlier date in the other matter, my lord, I had filed it and I have served upon my learned friend that matter pursuant to my lord's direction, my lord. However, my lord, in many of the matters, my lord, courts restrain from, my lord, sharing the report with the other side. It is between the, my lord, respondent bank and the court, my lord. After, my lord, having a look, if my lord thinks that this report should be shared,
My lord, without, my lord.
pages report, whether I have complied with the I have done the due
The
diligence or
respondent
not.
is directed to file the report on.
I'm obliged.
My lord,
The
my lord,
report
that has to be served, my lord, if it's in the form of an affidavit.
Let the matter appear on each night. The
Right.
respondents are directed to file report on the date fixed.
I'm obliged, my lord. Deeply obliged.
Let the report come. If it is
Lord.
confidential, I will see. If it is not, I will serve the copy.
I'm deeply obliged.
Very.
If it is against you, you naturally will get an opportunity. Let them file the report.
My lord, in this matter, I am praying for only not today, my lord. Like counsel is appearing. My lord,
If today, not today, March.
no, my lord, no, my lord. Kindly,
That is the
kindly
condition.
pass it over, my lord. Pass it over.
No pass over. This court is having two things. No pass over. Adjournment, March.
May I indicate only one thing? So far the prayer of the petitioner are concerned, this is, my lord, possibly
not with this determination. What is the prayer?
kindly have a look. They are basically challenging the police action. The arrest has to be declared illegal. So, my lord,
Armed
according-
disturbs under the Bharat and Nagari Sanhita, hurrying police. How this court?
This is my lord,
Welcome to prayer. Police in action.
overaction or otherwise, this has to go.
There is a overaction and also inaction, my
Well,
lord.
possibly in that
This court
event,
is not having. This court is not having the police authority.
except so.
I am releasing the matter mentioned before the appropriate court.
Grateful, my lord.
This court find that this court is not having the determination to hear the present date application. Accordingly, WPA number 27340 of 2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
So grateful that I get a very few chance to argue before your lordship. Very few. And I lost it myself.
But I am for the respondent bank.
Yes, same.
30 as well, my lord, on the
This is
21st.
against the classification of account
As fraud, my lord.
So again, we have the same prayer.
On the-
May I come back? The report.
On
Same
order
as per the prayer made by the counsel for the petitioner record. Same, huh?
21st, my lord.
On 21st.
Great.
Obliged. Urgent motion, my lord.
Urgent motion.
Urgent motion. Obliged.
I am appearing in item number 31, my lord.
My lord, the petitioner is an MSME. My lord, the challenge to the writ petition is not to any 13.2, 13.4 action. It is only with regard to classification of the account of the petitioner as a non-performing asset without following the mandatory guidelines. Your lordship's judgment is there in my lord Duar's jute textile and also Supreme Court in pronates. Yes. So my lord will kindly have a look at my lord my MSME certificate first, page 32. This really is undisputed, but for the sake of completeness, my lord, may I place it? Page 32 is the certificate. Then my lord will kindly have a look at page 36.
32, you are in
32, I am a micro industry.
Micro.
Micro.
Where it is?
My lord, kindly sees page 32, my lord, there is a table, type of enterprise. My lord will find in the fourth column, my lord, micro. Page 32.
Yes, 32.
Serial number 1 to the active.
Mobile number.
Now, my lord will kindly have a look at
Yes.
page 36, my lord, this is the sanction letter. My lord, 3rd of May 2023.
33.
36, my lord.
36.
Yes. 3rd of May 2023.
Yes.
Now, my lord, this is dated 3rd of May, and my lord, this is with regard to a cash credit. My lord will find that
Yes.
on the first page itself.
45. 495.
Now, my lord will kindly come straight away to page 43. 43. This is, my lord, the circular. My lord, the Hindi portion is there, but kindly comes to my lord, the portion in English, my lord, that starts from page 49.
59.
49.
Yes.
So, my lord, this is the notification issued in exercise of powers conferred under Section 9 of the MSMED Act by the central government, and is the framework for revival and rehabilitation of micro, small and medium enterprise.
Yes.
Now, kindly sees clause number 1, identification of incipient stress. So that is the first step which is required to be done by the bank. Identification by banks or creditors. Before a loan account of a micro, small or medium enterprise turns into a non-performing asset, banks or creditors are required to identify incipient stress in the account by creating 3 subcategories under the special mention account category as given in the table below. Well, pausing here for a moment, this is in the nature of a mandatory thing because the language is such that the banks or creditors are required to identify. Now, kindly sees the table there. SMA 0,
SMA1, SMA2, depending on the number of days of overdue payment.
Yes.
Now kindly seize serial number 2.
Principal or interest?
Identification by the enterprise. This would otherwise have not been relevant, but because this is a ground taken by the bank, that why have you not yourself done? So this is why I am just indicating.
That is the ground.
There are several other grounds.
Yes, but this is one of the ground. So may I just, since I am placing this, may I indicate? Identification by the enterprise, any micro or small medium enterprise may voluntarily initiate proceedings. So your lordship would see it is merely directory. But the languages are required in serial number 1, which is mandatory in nature. Then my lord will kindly have a look at serial number, clause number 2. This is what happens after, my lord, it is the committee is formed and the procedure. Then kindly comes to page 50, clause number 4. May I place it, my lord? Application to the committee for a corrective application plan. Any eligible stressed micro, small or medium enterprise or a bank or a creditor which has provided credit facilities to such an enterprise may file an application to the committee in the manner specified by the bank for a decision on a corrective action plan and in terms thereof. Then serial number 3, my lord. 2 is possibly not relevant here. Serial number 3. In case of disagreement between the participating banks or affected creditors or any issue before the committee or any manner contemplated in this framework, such disagreement shall be resolved in accordance with the regulations prescribed by the Reserve Bank of India. And I shall show that regulation as well. We have annexed that. The eligibility criteria and the grounds for filing of the application and the time limits within which such application shall be made will be in accordance with the regulations prescribed by the Reserve Bank of India. Now kindly come to page 51, my lord. The next page, clause number 5. Corrective action plan by the committee. The committee may explore various options to resolve the stress in the account. The committee shall not endeavor to encourage a particular resolution option for restructuring or recovery of the enterprise, but shall endeavor to arrive at an early and feasible solution to preserve the economic value of the underlying assets as well as the lender's loans, and also to allow the enterprise to continue with the business. So, my lord, the intent of this notification is to, my lord, allow continuation and to assess, my lord, the stress so that there is resolution. There is one can recover. Then kindly sees clause 4, subclause 4 under 5. First option is rectification, that is 4A, and 4.1, I'm sorry. Then
4.1
rectification, then restructuring, then recovery.
There are 3 steps, sir.
So kindly sees the language of 3, recovery. Once the first 2 options at A and B above, well, that is why I read it at A, but A and B above are seen as not feasible, due recovery process may be resorted to. The committee may decide the best recovery process to be followed amongst the various links. Now, my lord, we'll kindly have a look at the notice at page 56, which is the notice under section. I'm sorry, my lord, I should place page 55. My junior correctly points out, my lord. Page 55. There is a letter dated 24th of June 2025. For the first time, we have been informed that my account has been classified as SMA2 and will be turned NPA on. I'm sorry, I should show the date first. 24th of June 2025. Kindly sees the penultimate paragraph.
25th.
It starts with at present.
Yes.
At present, your cash credit account is under SMA2 and will be turned to NPA on. Kindly marks the date. 25/6/2025. The notice is the day before. 24th June 2025. This says will turn NPA tomorrow due to non-service of interest. You are requested to immediately pay the overdue of such and such and regularize the account. So I have been given 1 day for my lord NPA. Now my account is declared NPA on 25th. Kindly see page 56, 26th. I hope, my lord, all authorities act so fast, my lord, and not only the banks, but kindly see page 56, 26 June. 24th, first letter, 25th NPA, 26 June. Now, this is 13-2 notice. Page 58 kindly sees there is a table and they know it's NPA. My lord, that's evident from 55 as well, but 58 also. The type of account, serial number 1 in the first column, 58 MSME account. There's a table at page 58, my lord.
Yes.
First column, your lordship will first row, in fact, that it's MSME account.
MSME account, yes.
MSME account. Now, my lord, I reply to this, which is at, my lord, page 67. I say, please follow the framework. At page 69, the relevant portion, at paragraph 9 of my letter, it starts from, my lord, 67.
Yes. Yes.
It starts from 67. This is my notice, my lord, this is my reply. Then kindly comes to 69, paragraph 9. I rely upon this judgment of pronits and say, please follow the revival guideline.
Yes.
My lord, thereafter, interestingly, they withdraw the 13-2 notice. This is, my lord, dated 6th of September 2025 at page 80, my lord. So there is a demand, this is demand notice under 13.2, but kindly comes to page 84. They say the earlier demand stands withdrawn. They don't do anything in the meantime, so they issue this fresh 13.2. The NPA remains.
No, see, 26 June, NPA notice was issued.
Yes.
NPA declared.
Yes, NPA declared on 25th, 13-2, 26th.
Yes.
By this letter at page 80, they withdraw the 26th June letter.
Where is that?
Page 84 kindly sees, last paragraph after, starts at 80 at
Earlier
84.
notice 26 issued under.
Yes, is withdrawn.
This is withdrawn, stand withdrawn.
Stands withdrawn.
But this is, now they have issued the.
Now they have issued this.
Under 13.2.
Under 13.2. This is also under.
Okay.
Now, they have issued a further notice. My lord will kindly have a look at page 88. So same NPA declaration continues, my lord. There is no withdrawal of the NPA declaration. One notice goes, other comes, thereafter this. This is issued upon consideration of my reply.
Page 88.
Page 88.
Yes.
Relevant portion, my lord, will find page 89, the second paragraph. May I place it, my lord? Only one paragraph I shall place. In the aforesaid notice under section 13.2, dated page 89, dated 6th September 2025, you were categorically informed that the aforesaid account was classified as NP on 25th June in accordance with the applicable guidelines of the Reserve Bank of India. With regard to point number 1C and 1D of it, is to inform you that the first time the notice was issued, dated 24th June, account was in SMA 2 category and overdue on such and such, which did not include notional interest for the month of June 2025 as interest normally charged in the account at the end of every month. Subsequent to classification of account into NPA, that is 25th June 2025, the demand notice dated 26th June under section 13 was served upon you, and the breakup of total amount due was already mentioned. It is incorrect and false to say that within 1 day overdue charge was such and such. So, my lord, they say that because we say that on the next day, on the interest.
Yes,
now,
then?
page 91, third last paragraph, they say that the bank further submits that the account was rightly classified as NPA by the system itself as per guidelines of RBI. Kindly sees the guidelines of RBI now. And I'm sorry. Yes, kindly turns to the next page, page 92. Why I place that clause 2? They shift the burden to me at page 92.
Yes.
Now, the first paragraph at page 92, as regard to the framework. For revival of micro, small and medium enterprises, this is to inform you that the bank has never received such request from the company for any corrective action plan or restructuring. So they now shift their mandatory obligation to my directory obligation. Now kindly comes to page 94, which is the guidelines of the Reserve Bank of India. This is dated 17th of March 2016. Now kindly see towards the middle of the page. Clause number 2, identification of incipient stress. 2.1, identification by banks or creditors. Before a loan account of an MSME turns into an NPA, banks or creditors should identify incipient stress in the account by creating 3 subcategories under special mention account category as given in the table below. Then 3 categories given. On the basis of the above early warning signals, the branch maintaining the account should consider forwarding the stressed accounts with the aggregate loan limits above 10 lakhs to the committee referred in paragraph 3.3 within 5 working days for a suitable corrective action plan. Forwarding the account to the committee for CAP will be mandatory in cases of accounts reported as SMA2. 2.2 then, my lord. As regards accounts with aggregate loan limits up to rupees 10 lakhs identified as SMA2, the account should be mandatorily examined for CAP by the branch itself under the authority of the branch manager or such other official, as decided by the bank in terms of their board approved policy. On terms and conditions such as limits, procedures to be followed, etc., is applicable to the cases referred to the committee as referred to in paragraph 3.3 should be followed by the branch manager. So, when pausing here for a moment, none of these steps indicated has been followed by the bank. None. Then 2.3 is an identification by the borrower enterprise as well. Then it says, and any MSME borrower may voluntarily initiate proceeding. Kindly sees the departure in the nature of the wordings. So it is an optional thing, but for the bank, it's a mandatory thing before they could take steps. Now, my lord, we'll kindly have a look at 5.3. I'll just show, my lord, this is similar to that MSME also. 5.3a, my lord, is rectification, B, restructuring, C, recovery. Once again, the language. Once the first 2 options, A and B above fails, then, my lord. So this RBI MSME is really going in tandem with their respective, my lord, their respective, my lord, guidelines. Now, kindly sees page 98.
Yes.
At 105, is the relevant portion. This is the master direction of the Reserve Bank of India specific to MSME. Kindly comes to page 105, clause 4.8. 4.8 at the bottom of page 105,
Yes.
The Ministry of Micro, Small and Medium Enterprises, Government of India, Vedic Gazette such and such, notified a framework for revival. This is the first notification I had placed, for revival and rehabilitation of MSME to provide a simpler and faster mechanism to address the stress in the accounts of MSMEs and to facilitate the promotion and development of MSMEs. The RBI, the Reserve Bank, was advised to issue necessary instructions to banks for effective implementation and monitoring of the said framework. After carrying out certain changes in the caption framework in consultation with the Government of India, Ministry of MSME, so as to make it compatible with the existing regulatory guideline on income recognition, asset classification and provision, pertaining to advances issued by the RBI, the guidelines on the caption framework along with operating instructions were issued to banks on 17 March 2016, which I had placed. The revival and rehabilitation of MSME units having loan limits of up to 25 crores would be under, then this given. Then kindly see salient features of the framework. 1, 2, 3, and 4, these have been given.
So now what has happened?
Now they do not do anything. They had issued a 13.4 also, which is at page 65.
65.
65, they had issued a 13.4 also. But I had made 2 representations. My representation is at page 136 to Reserve Bank of India as with regard to this, there is really
Yes.
And page 130 is my representation to the zonal head of the central bank.
Yes.
On facts, this is all. Just the 2 judgments, may I indicate? First is the Pronitz judgment of the Honorable Supreme Court of India. We'll kindly have a look at paragraph 15 onwards. 15 to 22,
Yes.
Kindly see paragraph 17. In fact, I should place paragraph 15 also. Sections 21 and 35 of the said Act empowered the Reserve Bank of India to frame the policy and give directions to the banking companies in relation to the advances to be followed by the banking companies. Such directions have to be read as a supplement to the provisions of the Banking Regulation Act and accordingly are required to be construed as having statutory force and mandatory. Now kindly see 17. What is contemplated in the framework for revival and rehabilitation of MSMEs contained in the instructions or directions stated above is required to be followed prior to classification of the borrower's account, in the instant case MSME's loan account, as non-performing asset. The said instructions contained in the notification is such and such as part of measures taken for facilitating the promotion and development of MSMEs issued under the MSMED Act, followed by the directions of the RBI in exercise of powers conferred on such and such of the Act. And then contained, and as per the definition contained in section 2ZD of the SARFAESI Act, are bound to follow the same before classifying the loan account of MSME as NPA. But I was given not even 24 hours. Yes. Without any framework being followed. My lord will kindly have a look at paragraph 20 also and 22.
Correct.
And my lord, this judgment, though there is an interim order, my lord, but when kindly comes to page 14, this is while taking up a suit, where there was also an objection with regard to the section 34 of the SARFAESI Act being barred. But since the challenge was limited to the declaration of NPA being bad, so your lordship's pleasure was to entertain. Then page 14. When relying on the Pronitz judgment, then last paragraph at page 14. Going on to my page 15.
Yes. That's all.
There is one Madras High Court division bench we have found, which has also said it's it has to be followed. It's mandatory. Airdrop karo. Kindly takes a look at paragraph 14 at page 11 of the print. There's a page 11, paragraph 14. It starts from page 10. There's a box, then and possibly for in these facts we need not think out of the box, but still it's there, just out of the box. From the above table, it is evident that the accounts were declared NPA after 2015 only, and all other notices and proceedings under the SARFAESI were issued after 2015 only. In such circumstance, the bank is bound to consider the case of the petitioners under 2015 notification. If not viable, then only ought to have proceeded under the SARFAESI Act. It is pertinent to note that under the proviso in clause 2 of the notification 2015, the bank is entitled to consider for corrective action plan along with repayment facility also. When a comprehensive and viable method is prescribed for survival of the MSME and also for repayment to banks without exhausting the same, the bank has proceeded under SARFAESI Act only for repayment alone is against the 2015 notification. Then pronits is considered in paragraph 15. I am not placing that. Then 16 after the quoted portion.
Yes, madam. What is the contention?
My lord, admittedly, he is an MSME. Admittedly, my lord, at page number 55 is our first notice to him that your account would be classified as NPA. My lord, after which 26 June 2025 is our first notice under section 13(2) of the SARFAESI Act. His representation, my lord, starts from page number 67. My lord, I'll not take
Page 55, he issued on 24th June.
Yes.
And
26 June,
you
answers are given in 13(2). Now, my lord, 67 is his representation.
Correct.
My lord will kindly see at page 69, paragraphs 9 and 10 are the only two paragraphs where he refers to this RBI circular about MSME.
Correct.
But my lord, the other entire so many paragraphs in this representation which runs to around, my lord, 58, 60 or 75 paragraphs. Save and except these two paragraphs, there is no other reference about CAP or the MSME circular. Here also, my lord, all he says, if I could just place this, provisions of the framework as per RBI circular and notified by the central government have been blatantly violated by the bank. Also, in terms of the recent judgment of pronits delivered on so-and-so, same has been contemptuously avoided and disregarded by the bank. Bank is aware that the borrower is MSME, hence actions taken by the bank ought to have been in compliance with the directions and rules framed by the RBI and government for the MSME, which unfortunately bank has violated.
Correct.
Thereafter, my lord, we had recalled that notice, issued a fresh notice to him, my lord, in October 2025, to which, my lord, his representation is not on record. But, my lord, our reply is there, which starts from page number 88.
Correct.
Where, my lord, we have also dealing with his whatever allegation at page 92, we have said,
Correct.
As regards to framework, this is to inform you, bank has not received such request from the company for corrective action plan. Why we have said that, my lord? My lord, this is the decision of the Supreme Court. My lord, first of all, pronits is dated, my lord, 2024.
Correct.
Pronits is dated 2024. My lord's judgment is also 2024. Madras High Court, my lord, is dated 3rd June 2025.
Correct.
Post that comes, my lord, the judgment of 28 July 2025 of our Supreme Court.
Please give the reference.
2025 SCC online. It's Sri Swami Samat Construction.
Oh, okay. Yes.
My lord will kindly see from paragraph number 6.
Yes.
Here also, my lord, the insistence was that the bank had not followed the guidelines, hence could not have proceeded for recovery or under 13(2). The way Mr. Suvenso urges us to read the notification and the terms of the framework, if accepted, would
Where from your reading?
6, paragraph 6.
Correct. Yes.
Urges us to read the notification and the terms of the framework, if accepted, would lead to the conclusion that every lending bank secured creditor under the Act would be obliged to find out in every event of continuing default likely to give rise to classification of the account as NPA, whether the borrower is an MSME to which framework applies, whether its business has failed, or whether it is suffering from any disability to pay its debts. And upon receiving a response, to apply the terms thereof inter alia, including the account in the special mention account for the claim for a corrective action plan to be considered by the committee for stressed MSMEs. This could not have been the intention behind the framework of to aid MSMEs, which, for reasons personal to them, is unable to clear its debts and require revival and rehabilitation that the framework envisages. If indeed it is only the obligation of the lending bank creditor to identify incipient stress in the account, subparagraphs 2 and 3 of paragraph 1 would be rendered redundant. And MSME, despite finding that its business is failing or that it is unable to pay its debts or accumulation of losses equals to more or half or more of its entire net worth and classification of its account as NPS imminent, it would rest on its oars, believing that it has no responsibility and that its account will not be classified as NPA because it is the entire obligation of the bank to do what the framework requires. We would read and interpret the seemingly confusing terms of the framework harmoniously to ensure that a right under the MSME is not destroyed by the SARFAESI or vice versa. In our reading, the terms of the framework do not prohibit the lending bank creditor, assuming that it has no conscious knowledge that the defaulting borrower is an MSME, to classify the account of the defaulting MSME as NPA and to even issue demand notice under 13(2) of the Act without such identification of incipient stress in the account of the defaulting borrower. However, upon receipt of the demand notice, if such borrower in its response under 13(3)(a) asserts that it is an MSME and claims the benefit of the framework, citing reasons supported by an affidavit,
Correct.
the lending bank would then be mandatorily bound to look into such claim, keeping further action under the Act in abeyance, and should the claim be found to be worthy of acceptance within the framework to act in terms thereof for securing revival and rehabilitation of the borrower. Well, then paragraph 7. As has been noted, petitioning enterprise does not seem to have ever claimed the benefit of the framework after the demand notice was issued. Here, my lord, excepting quoting those two framework, he has not sought any relief. It is at the stage of compliance with an order passed by the magistrate under section 14 that this writ petition has been presented before this court claiming benefits of the framework to restrain the respondent number 2 and its officers from proceeding further under the Act and other enactments except in the manner contemplated under the notification. We find the bona fides to be suspect. Pronix is a decision of a coordinate bench of this court holding inter alia that the notification is binding on the lending banks. Finding to the contrary by the Bombay High Court in the judgment under challenge was quashed. Though while stressing that the framework needs to be followed by the lending banks before the account of an MSME is classified as NPA, this decision also lays stress on the obligation of the MSME by holding that it would be equally incumbent on the part of the MSMEs concerned to be vigilant enough to follow the process laid down under the framework and bring to the notice of the banks by producing authenticated and verifiable documents materials to show its eligibility to get the benefit of the said framework. It was cautioned that if such an enterprise allows the entire process for enforcing security under the SARFAESI Act to be over, or it having challenged such action of the bank concerned in the court of law tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for thwarting the actions taken under the SARFAESI Act by raising the plea of being an MSME at a belated stage.
Yes.
This decision, however, left unsaid something which we have explained herein above, while construing the terms consistently to prevent undermining the rights that one central enactment confers by another.
Correct.
No case of interference. Here, my lord, accepting in his representation under 13(3)(a) that there exists two frameworks which he have not followed, he has not given.
No. You have issued the notice on 14th of June 2026.
24th of June.
24th of June
Yes.
2025. Correct.
Yes.
Declaring that on 25th, if it's not
As
paid, it will
NPA.
declare.
As NPA.
Correct. Now 26th, just after one day, you declared NPA.
Yes.
You
Yes,
declared
ma'am.
NPA. Then when he made a representation to you
His representation, my lord, is dated
on August
13th August 2025.
2025.
No documents.
2025.
Yes,
But
my lord,
here the-
67.
Yes.
No documents, no affidavit, nothing to say as to why the losses occurred. And my lord, there's one more thing my learned friend would confirm. Last
But-
balance sheet of the company filed in
No, but the
2023.
problem is that the recent judgment which you relied upon, the Supreme Court has taken the strict cognizance on that, because that is only when the order of magistrate was passed for taking the
Yes.
possession of the property.
Yes, ma'am.
Correct.
Yes.
Here now you started that.
My
You
lord.
started here given the representation. You have stated your representation. Now you
Representation is, my lord, I have overcharged interest. I made wrong calculation. I have not given him the benefits of the loan. Therefore, my lord, accepting those two, it's only allegations against us.
So you decide. Okay, before proceeding with the surface say, you decided whether it is coming.
No, but then he has to give the documents by
Yes.
this and affidavit. He has to follow this. If he
Correct.
follows
Correct.
this,
Now
this
this
can be
judgment
done.
has come. Now this judgment has come. I am not setting aside your notice. Let the
If at all he wants to avail, he will avail.
submit all the documents before the authority
If at
to
all,
the
my-
bank.
Yes,
To the
ma'am.
bank along with the affidavit, and if the bank is satisfied, let it be submitted to the
Then, my lord,
submitted to the committee. Committee will consider it is coming under the purview of that. It is not coming, you continue with that. If it is coming, automatically it will go on.
Obviously, my lord, then the cap would
It
follow.
will go.
If it is not so, and my lord, one more thing, my lord, he will confirm, my lord. The company is not in business, has not filed annual returns since 2023. They do not even have.
That's why this code is only with regard to your master directions and
Yes.
the orders.
Will also see, my lord, accepting, since proneness is something that he knew, accepting quoting that and the circulars, my lord, there's been nothing given concrete as to how he wants to be considered under cap, the corrective action plan.
Correct. That's why either you could have been tell yes, what are the documents you could have been asked for. That has not been
My
not.
lord, then, my lord, like what this judgment also says, then, my lord, I would have to follow with every person as to what is your loss,
So this
why is
judgment-
there a loss.
Please. This judgment has come on the 28th of July 2025.
Yes.
And this is your June.
No, my lord, later one is of October. The last one, my lord.
Last one is written, but your notice
September.
and so
September.
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 Correct. And this is July.
So, my lord, I would go a step behind. This judgment is 28th of July 2025 as it fell from your lordship. The declaration of NPA is 25th of June.
That's what I'm telling.
So as on that date, which is the judgment prevailing?
That's what I'm telling. So that
So they cannot
keeping into the consideration of both the judgment, I am not asking with setting aside this two judgment, but you have been given liberty to make appropriate in terms of the judgment. You file, give all the documents along with the affidavit to the bank within a fortnight.
But I am not shying away from doing that. Well, only thing is today there is a 13.2, there is a 13.4, there is an NPA declaration. But I am contesting at the very root that the NPA declaration was made one day. I was given one day.
Correct. That's what I'm telling.
So, my lord, in that
this court is covering you.
Yes,
That
my lord,
is
only
covering
my lord,
you,
my lord,
giving you liberty. You file all the documents along with the affidavit in terms of the judgment.
I will. My lord, I bow down what is for infamy, my
This
lordship.
bank is not taking any decision. They will not proceed
My lord,
further.
thing.
If the committee find that you're not coming under the purview, the bank is free to take
But
this.
I am only making one humble submission in addition to what fell from your lordship. But your lordship is of the opinion, perhaps, my lord, that whatever notices are there, that should remain. NPA declaration should remain. But your lordship is giving me liberty to file affidavit or.
All
But
documents.
this is where I am, my lord, in my humble submission, not joining issues with only this part. But because, my lord, if I can satisfy that the NPA declaration could not have been done, then, my lord, that should go. That really would not prevent them from once again declaring me as NPA, once again taking steps under the Service Act.
So what?
But, my lord, today, as on date,
So what purpose? See, what purpose? NPA, you are nothing to doing with now the account. You have to submit the document within 1 week or 10 days or 15 days.
The time bound manner.
The time bound. So, and they will consider it within 2 weeks, 3 weeks.
Then they can declare it as NPA.
That's why if the committee finds that you are entitled for automatically, all the notice will be redundant.
Because only my apprehension may I indicate, and I want your lordship's protection for that, is, my lord, today when I'm going with that affidavit, already NPA declaration is there. But, my lord, I was humbly beseeching that if your lordship sets aside that declaration with the rider, that make it a time bound, that we need to approach, they need to, whichever way, and we need to comply by filing affidavits, all the accounts, whatever it's required, makes it a time bound manner and gives them a week after that to decide whether it's NP or not. But once that is done, then the
Madam, may I make my submission? I'm sorry to cut short my learned friend. I'm representing Reserve Bank of India, respondent numbers 4 and 5 in the matter. Similar question, identical question. It fell for consideration before your lordship. Few days back, I'll just indicate it to my learned friend. WPA number.
That judgment you are having.
I have, but unfortunately today I'm appearing virtually.
Yes,
I lost my voice, so that is why I could not be present.
Give
Yes.
the citation.
Yes, the citation I'll provide, WPA number was 27289 of 2025 in the case of Mohua Bhomik versus Union of India and others. The judgment was delivered by your lordship on 16th of December 2025. In that very case, your lordship had the occasion of considering both pronits as well as the Swami decision of the Supreme Court, the subsequent decision. But in that case, factually, it was only different to the extent that there the petitioner had made the application in the requisite form before the concerned bank, but the bank did not take action. So yes, now just if your lordship will allow me to place page number 94 once of the petition. Page number 94 is the framework for revival, which was placed by my learned friend. If your lordship now looks at 2.1 below, identification by banks or creditors, your lordship will find that the table shows the categories SMA 0, SMA 1 and SMA 2. What happens is this basis of classification is this, that when the principal or interest payment remains overdue for a certain number of period, if it remains overdue for more than 30 days, then it comes under SMA 0. Then if it goes beyond 30 days up to 80 days, it
SMA
comes
1.
under SMA 1. Then 81 to 90 days, when it remains outstanding, then it goes in the category of SMA 2. So once the account slips into the category of SMA 2, then from the 91st day, automatically the system considers the account as NPA. So NPA doesn't actually depend on the declaration of the account to be so by the bank. It is system generated response on the basis of when the interest remains overdue for a certain number of days. Now, this corrective action plan will only come in effect once my learned friend provides with the necessary application in the correct format to the bank for the bank to consider as has fallen from your lordship in that decision as well. And in that decision, where your lordship had the occasion to consider pronits recently, there also your lordship held that whatever demand was raised by the bank without having generated the corrective action plan or taking steps for referring it to the committee concerned, there also your lordship said that all those actions will be kept in abeyance till such time the entire application is considered by the bank. Those are my respectful submission, because the application, like the complaint which was lodged with Reserve Bank of India, which was placed by my learned friend at page number 139. Your lordship will see the date was 28th of November 2025. And the date on which the writ petition has been affirmed is the 2nd of December. So there was only 2-3 days in between. So they did not give us an opportunity. I've taken instruction. Already, Reserve Bank has already processed with the complaint. They are taking steps with regard to the complaint. However, in the meanwhile, these may be done by my learned friend after taking into consideration your lordship's recent decision.
My lord, only one more
Those
thing.
are my respectful submissions.
My lord, this letter at page 55, 24 June 25, where we had just informed him that your account would slip into NPA tomorrow. That was not required. There is no provision of law where I'm supposed to give him notice. I could have straight come with the 13-2. So, my lord, him complaining that you come to me on the last day and you classify the account as NPA. This is an additional information to you. You cannot take advantage of this letter. But when you have received 13-2 and you have made the representation, you have not complied with it and you made the representation post the last decision.
Okay, I will take care of it.
2 minutes in reply to both. But possibly the contention of my learned friend appearing for Reserve Bank of India that the account automatically turns NPA is not correct from these guidelines. But your lordship would see that here there is a classification of SMA 0, 1 or 2. That needs to be informed. Then the mechanism kicks in.
That's why the notification or the guidelines which the bank or Reserve Bank of India has issued, that says something. Now interpretation has come in other way. We have to go by the interpretation made by the Supreme Court.
Correct. Yes. Yes.
So now we cannot say no, the Supreme Court has not dealt with that.
Right.
Not only that, my lord has done these matters, my lord, these classifications.
That's why. That's why now the matter has been already set in
So,
rest.
today, as you
So instead of giving again, the bank should come with the fresh on.
today we are what facts
I am keeping in abeyance with all the notices. Let they take you file, because there is a format also. There is
Yes,
a
I will,
format
but I am not shying away.
format along with all these things within 2 weeks, whatever it is, as per the
My lordship would make it a time, but only thing which I am joining issues, my lord, humbly, my lord, is my lord, with regard to the fact that your lordship is not uprooting or undoing the declaration of NPA.
Correct.
Because
why I am telling. So that's why I am keeping in abeyance the whole proceedings initiated by the bank, including the NPA. It's come because how the
so let the NPA declaration be stayed till such time they take the decision.
Total initiation be kept with the kept in abeyance, because the surface how the surface has started
by NPA.
NPA. So I am keeping abeyance all the proceedings initiated by the bank till the decision is taken by the bank on your application. That is my order on the last of your.
I will.
That's all. Hearing concluded. CAV.
Grateful to Raj.
May I have your kind?
What is the date of the order, madam?
Yes, Your Lordship, the date of the judgment was 16th of December 2025.
27289.
27289 of 2025, Mohua Bhomik versus Union of India.
Oh, thank you.
Till such time the order
Brief.
comes, let them not. Till such time the order comes, they let them not.
Please see to that. Matter in session, not to take any further.
It is understood.
Have a
It
kindly
has
to
been
mention
passed in
one
presence
matter.
of all the
Yesterday,
parties.
upon hearing learned senior counsel Mr. Suman, that lordship was pleased to list the matter tomorrow as an urgent motion, but today it is appearing as item 469 as new motion. Lordship kindly consider.
You are not mentioned in the urgent motion list.
Lordship,
whatever the this mentioning list has been given as
Lordship,
urgent.
upon there is a writ petition that was being heard.
Have you given the urgent
Yes,
list?
Yes, Lordship.
Where is the mentioning list? You are mentioning list because
Yesterday.
now this court is taking care of the personal looking the urgent mentioning list. So, see, I am kept
One
separate.
writ petition was heard, a connected writ petition was filed. Lordship said that it will be heard day after tomorrow as a urgent motion. Today it is appearing as new motion, item number 469. Lordship kindly keeps that matter as a urgent motion tomorrow.
What is the urgency?
Lordship, my contract has been terminated. They have terminated the contract on the basis of the test conducted behind my back. All what we are praying is that a neutral person be appointed by the court so that test can be freshly conducted. Item 469 of today's lordship is.
Why not कर लो
tomorrow as
urgent motion tomorrow करके मेरे पास लेके हम देखते करो.
My lord, with regard to item number 52, my lord,
Which one? Appellate side?
Appellate audience side, my lord.
Let origins, yes.
My lord, may I believe item number 16, original side, contempt matter, my lord. On two.
Yes, origin side has noted, my staff has not come, yes.
My lord, it is due to very grave urgency. I am mentioning, my lord.
Sir, please
My-
wait. Yes, leave us appeal side.
My lord, item number 16, contempt matter, my lord.
16.
My lord, your lordship was pleased to pass an order. Injunction was disposed of on 25th of September 2024, my lord. And your lordship was pleased to direct the contemnous defendants to pay the monthly maintenance of rupees 14 lakhs and 11 lakhs that could not. They were directed to deposit rupees 80 lakhs to restart oil. They did not. They were directed to submit the statement of profit loss. That did not. My lord, at least that should be. We are suffering. We are not getting.
The contempt application to be taken expeditiously.
Yes, subject to lordship. At least lordship, subject to lordship.
Take today if you're ready. I am here till 4:30. If you're ready to take, I will take the matter today.
My lord.
Only I can do. If the bar support taking aside the bar resolution,
No, no.
ready to
No, no.
matter, then
No.
you are keeping your resolution intact, and you are mentioning the court, seeing the list of the court.
My lord.
Where your matter is to be listed, or I give the list to the advocates where your matter can be adjusted, I will adjust.
My lord, may I only submit this subject lordship may fix the matter on any day, my lord. Subject to lordship pleasure, my lord.
I have not taken the hearing matter today due to the appellate side matter.
I appreciate, my lord. At least since we are suffering, my lord, that reason, my lord. And they were brought on record.
Before this court, all matters are.
They were brought on arrest.
My lord, may I seek my lord's leave, my lord?
Yes,
Mention one recalling application, my lord, for inclusion in the list. Recalling of your lordship order, my lord, dated 22nd December 2022. Your lordship remembers, my lord, there was a Section 8 application filed by the HDFC Bank. My lord, posting the matter for arbitration. Your lordship consented to that order. My lord, directed the matter to my lord referred to arbitration. We challenged that before the my lord Honorable Supreme Court. Honorable Supreme Court had dismissed the matter on the ground that a criminal contempt has been filed by me because the matter has been sent for mediation, wherein my lord fraud documents have been given by the bank. Which we
Whether you file the review on that,
my lord, a recalling application has been filed. My lord,
review of the Supreme Court order, you're not.
No, review till not filed, my lord. We are taking our chances before your lordship in the recalling application. What happened in the meantime? The matter has been referred for arbitration. My lord, on 15th of January, my lord, a date was given by the learned arbitrator for filing of the statement of claim. My lord, if my lord,
Why recalling? What is the recalling now? The Supreme Court has upheld
no,
there.
Supreme Court dismissed it on the ground that a criminal complaint has been lodged by me, not on merits.
Whatever it may be.
Not on merits, my lord. I have annexed all the orders. My lord, let the matter be appeared any day. My lord, before 15.
15 January, before 15. How?
Any day, my lord, before 15.
Only 1 day is remaining.
2 days, my lord, 6, my lord, any day before 15th of January.
13 तारीख को रखो to be mentioned.
May I leave to mention item number 52, my lord, of today's list. This is a testamentary suit, my lord. There is a matter going to up to.
I will do one thing. From tomorrow onwards, I will sit at 9:30. All mentioning will be taken from 9:30 to 10:30. 10:30 onwards, no mentioning. Neither 10:30 nor 3 p.m. I will sit at 9:30 with my 2 officers only for taking the mentioning list. If your bar is ready, I will take all the mentioning matters. If the bar is ready, I will sit at 9:30. I have no work.
My lord, item number 52. This matter went to Honorable Division Bench. Division Bench directed that we have a partition suit. That partition suit and this testamentary suit will be tagged together.
52.
52. My lord, may I hand over the copy of the mentioning slip? There, the PLA number is.
What the appellate court
My
passed?
lord, this is the observation. I have. Sorry, my lord. I have marked, my lord.
Partition suit and the probate proceeding are required to be heard analogously, being given in the probate proceeding. However, we are not interfering with the interim order. So So what do you want now?
A testamentary suit is running before your lordship, and PLA, civil suit CS may be tagged with this PLA.
Where is the CS?
That is with the department. That
Go to the secretary chief.
My lord, I went to
Mention that.
I went there.
Ah.
It was cannot be assigned because the suit is released by the Honorable Justice Sugata Majumdar. And if lordship call for the record, they will send the record with the the department will send.
But unless and until the assign is not.
I prayed for assignment, but that was refused.
Who?
By the secretariat, chief secretariat, my lord. So
how this court can?
My lord, the report.
If any decree is passed, then will be nullity.
I understand,
Without
my
the
lord.
assignment.
But that was not done, my lord. I have sent the.
Where is the application before the
my lord?
Because I cannot.
I understand, my lord. My lord, kindly make it to be mentioned tomorrow. I will produce the letter which was
producing. What can be done? You have to produce the assignment order.
Assignment letter. I will produce, my lord. Kindly make it tomorrow, my lord, to be mentioned. I will produce it.
My lord, only one matter, my lord. Arguments are complete on behalf of plaintiffs. Matter is in item 61. Any timely fix every lordship.
Argument is completed, then who will write the judgment?
The plaintiff, the defendants have not completed, my lord. Any
defendant, who is for the defendant?
I have served notice to
But they are not here. They are not ready to argue the
the
matter.
They are taking only time and time. Only that
Today there is no. You mentioned.
I have given notice and mentioning the matter, my lord. With notice, my lord. Any time we fix, let them come. Any 3 p.m. Any day, 61.
14 तारीख to be mentioned.
61. Any day.
Yes.
My
Sorry, Mr. I was taking the matter.
Lord, I think, Lord, I asked for that trouble yesterday by falling for that. Lord, your lordship smiled, saying, Lord, although someone else should have been making submissions. I fell into the trap.
We were waiting because even if there was one run scored, we would be held as the fielding team and we will get our match fees.
I told him no singles, only sixers.
Han says, no, I'll only hit 6 runs, so no batting today.
Okay, thank you.